And hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, and we are here with our continuing coverage of the Alex Murdaugh trial. And I want to start this morning by talking a little bit about this question about, did Alex Murdaugh open the door? There has been disputes over a door. Do we have a door or do we not have a door? So the question, basically, for those of you who are a little bit unclear about what we're talking about, is, can certain evidence be brought in that would be potentially character evidence about Alex Murdaugh, but might also be Alex Murdaugh's motive? So we're going to just spend a little bit of time on the rule on this issue. And then we're going to hear the judge discuss it in some detail this morning as well, because he said that he wants to get into this issue because he has not ruled on this issue in preliminaries, is my understanding. He has deferred the issue, and the prosecutor's like, we'd like to talk about it now. And so the judge is like, well, I guess we have to have a hearing on it now because I can't avoid the issue anymore. The judge has, to my understanding, said, I'm not going to rule on it until the question's asked, and the prosecutor, being good prosecutor, unlike Binger, is saying, hey, judge, I'm now going to ask the question, right? I'm not springing on you. I'm telling you I'm going to do it. And so the judge is like, well, I guess we have to have a hearing on it. So that is what we're doing in relation to that. So the relevant rule is Rule 404. This is the same rule in the federal, well, it's the same number in the federal system, but it's also it's a very similar rule here. So Rule 404, character evidence not admissible to prove conduct, exceptions, and other crimes. All right. Evidence of a person's character or trait of character is not admissible for the purpose of proving an act in conformity therewith on a particular occasion. So you can't offer it for this purpose, the purpose of proving act in conformity, unless character of the accused. Evidence of a pertinent trait of character offered by the accused or prosecution are about the same. Now, as to A1, do I think this exception applies? No, because the witnesses that have been asked about their character, to my mind, have been asked about their family relationship. Did they have a good family relationship? And so if we're trying to get into the financial crime stuff, if we're trying to bring in he committed a bunch of financial crimes, that doesn't really rebut that. So if they have something more specific, like if they have evidence that all was not right in terms of the familial relationship, if the wife was really seeking a divorce, for example, if the wife was not staying at the home, then maybe, right? So you could offer that kind of evidence, because it would only be evidence of a pertinent trait of character offered by the accused. So the relevant question is, what questions has the accused asked, or what evidence has the accused solicited with respect to what particular pertinent traits, right? So you can't offer all character evidence, only pertinent traits of character. So that is sort of the first thing I would say. So the best I would say is that they've talked about his general lovingness as a father, his lovingness to his son, and stuff like that. Can you talk about the financial crimes? No. Can you talk about why he really wasn't a loving father and why they were having problems? Yeah, maybe, if that's the question. But then that's the question. What are we exactly talking about? So that would be my thing. But there is another exception. And this is where the judge seems to be wanting to go anyway. So it's not 404A1 that's really the issue, it seems like. It's 404B, because we can offer it, as I mentioned. We can't do it for the purpose of proving conformity. We can't do it for that reason, but we can bring in character for other reasons. And that's where we get into 404B. And so this is why so 404A1 is opening the door. That's the opening the door. So when you say opening the door, that's what we're talking about. The accused is offered in evidence the prosecution gets to rebut. That's opening the door. But you don't necessarily need the door, because you got 404B. Evidence of other crimes, wrongs, or acts is not admissible to prove the character in order to show act of conformity therewith. We just learned that from A. But it may be admissible to show motive, identity, the existence of common scheme or plan, absence of mistake, or intent. And this is where the prosecution is trying to shove this in. They're trying to shove it into motive. And so that's what the hearing today seems to be about the issue about motive and whether or not this is proper motive evidence. And the defense's argument so far has been, this is just ridiculous to say this is his motive, which, I don't think it's an argument completely without merit, but that's why it's a judgment call. It's literally a judgment call. And the problem, of course, is if you're bringing in evidence that shouldn't be brought in under this exception, and it prejudices the defense, you're setting yourself up for an appeal. So that's the problem. So you want to, as a judge, be cautious, all things being equal. You want to be cautious before allowing, and for that matter, A1 either, you want to be cautious for bringing in evidence for this reason because, well, you're not supposed to bring it in unless. So you kind of want to make sure unless applies. And the judge seems to say that they need to show, in order to bring this in, the judge said what he seems to say is that he is expecting them to prove it by clear and convincing evidence, which is a heightened standard of proof. So they need to be able to show that this exception applies not by probable cause, not by preponderance of the evidence, not by proof beyond a reasonable doubt, but by clear and convincing evidence, which if you're looking for a percentage is something like 70, 75%-ish, something in that neighborhood, right? Whereas beyond reasonable doubt is 95% plus and preponderance is 51% and the probable cause is like 30%. So the judge has basically indicated that he's looking for a 75% reason to bring this evidence in, or he's not going to do it. And that seems to be where we're going on all that. So there is your morning education on all that stuff. And also, I think that the prosecutor and the way they asked the questions last night of that witness was very slimy in response to the question in chat. It was incredibly slimy. That's improper questioning in my mind. He can't ask those questions at that time in that way. He might be able to ask those questions of some other witness in some other way, but he couldn't ask those questions of that time to that witness, in my view. There was no foundation that he would know those things. There was no foundation. It assumed facts not in evidence. It was essentially testifying, which he can't do because it's direct. Even if it's redirect, it's still direct. So you can't bring it in because of cross-examination, because it's not cross-examination, it's direct, just direct phase 2. So I think it was very slimy. The judge is overruling the objection. Maybe that's indicative of something, maybe not. For me personally, based on what I've heard at trial, and this judge has obviously been dealing with this case a lot longer, so the judge's ruling may conflict with this, and that doesn't necessarily mean he's wrong. Although if I still think he's wrong at the end, I'll certainly tell you so. I'm not afraid to. I just take note that he's been dealing with the case a lot longer and had a lot more time to consider these issues and been asked this question before in preliminaries. It's not his first time hearing the question, where it's basically my first time hearing the question. But for me, I'd be somewhat disinclined to bring this in at this time. There is not enough foundation that's been brought in for my mind to trigger 404B. The motive at this point is just kind of too speculative. It's just not enough for my taste. But that's me. So that's sort of my analysis of the thing and my view of the thing as we sit right now. But we're going to learn a lot more from the judge this morning as he actually gives the ruling and stuff like this. And if the judge actually gets into explaining his rationale and he goes through it, it may very well be that he convinces me. And I'm certainly open to that possibility. I'm always, well, at least on this occasion, I'm willing to be proven wrong because I haven't been thinking about it long enough, right? If I'd been thinking about it longer, I might come in with a more settled legal opinion, but I haven't been coming in with it long enough. And so, I'm not afraid to disagree with the U.S. Supreme Court sometimes because I've been thinking about it long enough. And I'm like, yeah, the Supreme Court's wrong. So sometimes I'll disagree with the Supreme Court, but that's only because I've been thinking about it a while and really thought through it. I'm like, no, that doesn't make sense. On this occasion, that is not true. So I at least at this time, I'm willing to be convinced that I am not correct. So we'll see how that all pans out this morning. We are continuing our coverage also of Seal, Clock, and Chandelier, and we'll see how it's going on. So we'll see what's going on. Yeah. And also, of course, I think it's also worth noting, by the way, that Emily D. Baker appears to disagree with me. I haven't heard what she said, but it's just been reported to me that Emily D. Baker disagrees with me. And that's fine. Different lawyers think about issues differently. I mean, I just read you the rule. I read you the standard. And it's a judgment call to some degree. It's a judgment call of when that triggers.
Good morning.
Right? It's a judgment call. I mean, I just read you the rule. The question are, did the facts trigger the rule? And
First,
so
I want to address the
just as a note, there's no like
ruling yesterday overruling the objection by the defense to the state's question of the witness on redirect as to whether he was aware of certain things that had occurred earlier on June 7th involving Mr. Murdaugh, or Murdaugh, Duck. In the questioning, cross-examination of the witness by Mr. Griffin, the witness was asked whether he could think of any reason, the gist of it, if he could think of any reason possible why Mr. Murdaugh would commit the crimes he's accused of committing. That, in effect, turned the cross-examination of that witness from dealing with the specific issues in the case to having that witness testify as a character witness for Mr. Murdaugh. Among his other areas of inquiry was his being a loving father, great provider, financially secure, things of that nature, all indicating an opinion by that witness as to the good character of the defendant, either through direct statements or circumstantially through the evidence that was adduced from that witness. In the court's view, that opened the door for the state to respond by asking questions, as the state did. Hence, the court overruled the objection. In addition to all of that, the objection was totally inappropriate. As the court laid out and reviewed with the parties early in the trial, that objection should be made and the legal basis stated. An objection of totally inappropriate is, in the words of Judge Joe Anderson, in effect, no objection at all. That's not a legal basis for an objection. That summarizes the basis for the court's ruling on that issue as to those questions yesterday. And that character type evidence was not only sought by from Mr. Gibson, but also, was it Loving? But also Mr. Loving. And none of that really implicated Rule 404, 404B.
Right, because that would be all A1.
One, it opened the door. Number two, it's 404A type reputation, questioning that the state had a right to respond to per the rules. And thirdly, it addressed an issue raised in the case by the defense. The defense in the case has primarily been the defendant has such a great character that he could not possibly have committed these offenses. That's been a general thread from opening statement throughout. In addition, the defense introduced through that witness, which was also introduced through other testimony in the case by the defendant, that the boating case was a reason for the murders to have occurred, and by the defense inquiring of the witness yesterday as to his knowledge and belief concerning, or his knowledge concerning the boating case, that likewise opened the door for the state to address that issue. And that's the basis for the court's ruling as to opening the door, introducing the boating case, and reputation type evidence that the state had a right to respond. Under Rule 403, yet to be addressed by the court is Rule 404 issues.
I think you meant it the other way around.
Those issues will, to some degree, have to be addressed in camera, and I'm wondering if the state has other witnesses to testify as to other things, since we have the jury here ready to go, prior to addressing any other.
Well, we do have first of all, we do have a Snapchat custodian who has flown in that we need to get in so that person can make the flight. Based on how things ended yesterday, I was prepared this morning. We were planning on going forward with some of the witnesses from the law firm, and that's going to, there's certainly stuff beyond 404, but that's also going to put some of the 404 issues squarely into play. So that's kind of where we were planning to go this morning, Your Honor, with the testimony that we have. I can certainly get some more forensic people rolling. I apologize if I sort of misread what we needed to be ready to do, but that's kind of what we focused on last night and are ready to address this morning.
Yeah, well, the court didn't have a lot of time to do jury planning issues, and it might have, the jurors typically come at 9:30. It might have been a better idea had, with greater thought, to have had them come later. But I don't know how long these issues will take to be addressed.
I think with the two law firm witnesses out of the gate, I think once the court has
Snapchat custodian is definitely a real record,
focused in camera testimony, and I think that for
Custodian
those
of record.
witnesses, the court can then rule on what's admissible and what's
Definitely
not,
real,
and once that's done, then we can get underway with the jury for those witnesses and proceed accordingly. And then, of course, we can certainly have a discussion as far as other witnesses, and then perhaps arrange a time to do any other in camera. But I think setting the table with these two witnesses is going to set the table for many of the issues that, whether they're in or out, that the court has to decide.
All right. Well, first, as it relates to Rule 404, and Rule 404B states that evidence of other crimes or wrongs is not admissible to prove the character of a person in order to show action in conformity therewith. In other words, not admissible to show propensity to commit the crime or a crime, but it may be admitted for certain other reasons, including motive, identity, intent, and perhaps the existence of a common scheme or plan. Additionally, well, I'll address it later regarding res gestae, but
Res gestae just
my
means
view of the
the thing
evidence
decided.
is that evidence
Means I've already decided the issue,
the
basically.
other alleged crimes can be introduced in this case to show motive,
It's already been decided somewhere else.
intent, common scheme or plan. Given the proper analysis as it relates to that evidence being offered. As I indicated earlier, that the court agrees with the view and as expressed by the court in U.S. v. Siegel, 536 Federal 3rd 306, wherein the court addressed the issue of previous crimes involving, previous alleged crimes involving multiple victims, and that the state should be able to pursue its theory of proving that why suddenly, or why some such tragic, the motive for such tragic and occurrence
gift memberships
to have taken place on the dates alleged here. And under the federal rule, it goes on to say that evidence of other crimes or bad acts is necessary if it is an essential part of the crimes on trial, or where it furnishes part of the context of the crime. This state has not adopted that portion of Rule 404B, but the courts have addressed that issue in some of the cases, particularly one that stands out to me as one of my cases, State v. Frankie Lee McGee from Richland County, in which the res gestae was used as a basis for the courts properly allowing certain evidence, including evidence of commission of an earlier crime, the test being whether it logically relates to the crime with which the defendant is charged. Court states in that opinion under res gestae that one of the accepted bases for the admissibility of the evidence of other crimes arises when such evidence furnishes part of the context of the crime or is necessary to a full presentation of the case, or is so intimately connected with and explanatory of the crime charged against the defendant and is so much a part of the setting of the case and its environment that its proof is appropriate in order to complete the story of the crime on trial by proving its immediate context or the res gestae or the uncharged offense is so linked together in point of time and circumstances with the crime charged that one cannot be fully shown without proving the other, and thus is part of the res gestae of the crime charged. And where evidence is admissible to prove this full presentation of the offense, there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. And interestingly, involved in that case, the court held that did not require a 403 analysis. because the evidence was properly admitted as part of the res gestae, the issue of whether or not a 404B analysis was done was not necessary. And at this point, the court hasn't addressed any particular issue under 404B, but I find that it is admissible provided that the proper scrutiny is done in relation to clear and convincing evidence and a logical relationship to the offense for which we're having this trial. And additionally, as relates to intent, evidence tending to prove a defendant's state of mind or intent at or near the time of the crime is relevant to establish possible guilt. So there are many areas under which it's appropriate for the court to consider admitting this evidence of other crimes, other bad acts, in a manner that does not address or seek to have the jury conclude that it's propensity evidence, and the court will address all of that as we proceed. Yes, sir, Mr. Griffin.
Thank you, Your Honor. I just want to get some arguments on the record for purposes.
Yes,
as to Your Honor's conclusion that we opened the door by presenting evidence of good character, I would respectfully disagree, and the evidence that we presented was specifically limited to the relationship between the defendant and the victim for which he's accused of murdering. In our view, that is not character witness. That's a factual issue relating to the relationship between the parties. And so I just want to put that on the record. Your Honor puts great emphasis and reliance on U.S. v. Siegel, and that's a federal case. And I want to point out that
I gave the site, federal site. Yeah.
Yes, sir.
Federal second. Yeah.
The federal site is 536 F3rd 306.
F3rd, yes.
Yes, sir. And and it's important to distinguish the federal crimes for which the defendant in Siegel was charged with. First, the defendant, she was charged with murdering the victim to prevent him from reporting fraud, and that's a specific federal statute, 18 U.S.C. 1512 A1C. She's also charged with impending an official investigation by transporting the deceased body across state lines. But further, the indictment alleged a broader scheme and artifice to defraud. And in the indictment, it listed many of the prior crimes that the defendant committed in the federal indictment. And so, and under federal rule 404B, you can prove those up. And then there were others that the court considered they were related to the whole scheme and artifice to defraud. The indictment in this case, Your Honor, is simply on June 7th, 2021, the defendant with malice aforethought murdered Ms. Maggie Murdaugh, murdered Mr. Paul Murdaugh, and used violent weapons in commission of those two crimes. There's no scheme and artifice to defraud here.
You're currently addressing it as if the court ruled based on 404. And the court clearly stated that we have not reached any determination on 404, that the basis of the court's ruling was 403, the boating case, as you introduced through the witness, and opening the door by giving testimony, soliciting testimony of generally good character of the defendant such that neither of the two witnesses could possibly imagine the scenario under which what would cause this crime to have occurred, entitled to confront that evidence in the manner in which the court ruled. But you're arguing 404. I cited that for an additional basis to say the court will need to look at all of that as we proceed with evidence of prior bad acts, but the basis of the court's ruling was not 404, but 403.
That makes no sense.
Opening the door and responding to the evidence that you adduced.
That makes no sense. You can't. That makes no sense. What do you mean you're using 403 as a basis? What? That doesn't make any sense.
It was not 404, but 403. Opening the door and responding to the evidence that you adduced.
Yes, sir. Hearing outside the presence of the jury on their proposed 404B evidence?
Yes, sir.
Okay. Then I can save all the arguments from then. Thank you.
Yes, sir. And again, with regard to planning purposes for the jury, you said a witness, whatever can be done without getting into the 404, the court's need for an in-camera hearing, where we need to dismiss the jury for whatever period of time that might be. We can press on with what you have otherwise at this time, and whatever that is what we'll hear.
Yes, sir, Your Honor. Like I say, we have one short custodian, and then I think our next witness who's here would be somebody where we would need to address some of the 404. That would be Jeannie Seckinger from the law firm. If you give me one moment, I can to confer with my staff, and we can see if we can get some other people rolling so that we can kind of stagger that and continue to have presentations for the jury during the course of the day.
All right.
Okay. He says he's admitting it. He says he's admitting it under Rule 403. That doesn't make sense. Rule 403 is a rule to exclude, not a rule to include. Rule 403. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, considerations of undue time, delay, waste of time, or needless presentation of cumulative evidence. 403 is a rule to exclude, not a rule to include. 403 is a safety valve. 403 is a rule that says, hey, even if the evidence is admissible for some other reason, you can still kick it out anyway. So 403 is an exception to 404, among other things, right? So 404 is an exception. Here's why you can bring it in. 403 is an exception to the exception. Here's why you can keep it out. It doesn't make sense to say, I'm admitting it under 403. That doesn't make any sense. That doesn't make any sense. 403 is the reason you kick it out. 403 is, hey, it's admissible, but I'm not going to do it anyway because 403. He says, I'm going to admit it, not under Rule 404, but Rule 403. That doesn't make any sense. That's a legal error. That's legal error. That doesn't make any sense. That's legal error. That doesn't make any sense. So if the judge had said, I'm admitting it under 404, then I would have said, okay, that seems, if the judge had said, I'm admitting it under 404, I would have said, I disagree, but I can see it. If the judge is saying, I'm admitting under 403, I'm like, no, you're not. That doesn't make any sense. I don't get it. So is it appealable? Very much yes. It's a clear error. It's clear error. It doesn't make any sense. It makes no sense, right? So yeah, if the judge had said 404, clear error would still be the right issue. It would be clear error. And as an appellate judge, I'd be like, well, maybe I disagree, but can I overrule the judge as the Court of Appeals, right? This is where you get into, you have to consider things in the right mindset. So if the judge had said 404, I probably would have said, well, I disagree with it. If I'm the judge, I probably wouldn't allow it in under 404. But if I'm the Court of Appeals, I can't overrule it, because the issue is clear error. Is the judge in clear error or abuse of discretion? But this is really a clear error issue because it's a legal determination. Does the question is a legal determination. So clear error is the right standard. So if the judge had said 404, I was like, well, I might have disagreed as a judge, but can I overrule it? Probably not, as the Court of Appeals. If the judge says 403, I'm like, can I overrule it as the Court of Appeals? Yep. That doesn't make any goddamn sense. So that's what I think. So as to whether they open the door through the question, I think the defense's argument has it better. I think the defense argument has it better in terms of whether it's a character issue. But I could see the judge disagreeing with the determination because it's literally a judgment call. That's why they have judges. It's literally a judgment call, right? I think the defense's argument is the more persuasive, but that's me, right? So if you're asking me, did they open the door? I find the defense's argument more persuasive, personally. It's like, that's not really character evidence. It's going to the fact issue of this particular issue. And then I quoted you the relevant rules under 404, right? And it's like the pertinent character trait. So even if it does open the door, it would open as to that particular pertinent character trait, right? So first of all, I don't think it opens the door. Second of all, even if it does, it would, to my mind, open it as to, okay, show me evidence that they're not such a lovey-dovey family. Do that. Then we'll talk, right? Does that open the door to all character evidence? No, that's not the way I read the rule. But if the judge had said, I disagree with all that and I'm going to do it anyway, I'm like, well, if I'm the trial judge, I would do something different. But as the Court of Appeals judge, I'm not sure I can overrule that. Because the Court of Appeals standard is the judge in clear legal error. And no, it's a judgment call. Just because I would disagree with the judgment call is not sufficient to overrule it as the Court of Appeals. But if the court says I'm admitting it under Rule 403, I'm like, what the hell are you talking about? That doesn't make any sense. And so now you have all that problem. So good times. But it also feels like the judge is not being very clear about exactly what he is or is not admitting. I'm not exactly sure what's admissible or not going forward. He thought the question yesterday was proper with respect to that, but I'm not sure that he's made a positive determination going forward as to what things is or are not admissible. So I don't know where the judge is sitting on that issue. And so that's what I think for any value it has. Yeah. That's what I think. I don't know that it's bias is the issue, Clipsy. I don't think that's necessarily fair. I don't think that's necessarily fair. As I've been going to some pains to say repeatedly, it's a judgment call. It's a judgment call. Is this rule triggered or is it not? Do you think the defense opened the door under A1? Do you think, to what did they open the door, if they opened the door at all? And then, of course, you can also get past that complete issue because you can also say, well, whether the defense opened the door or not is completely irrelevant because 404B, right? So I can do it for that reason. So, like, I can go 404-1A and say, well, they didn't open the door, but if they did, they only opened it this way. And also whether they opened the door or not is completely immaterial because 404B. Right. So I don't assume bias. I just assume that the judge has a different view of the issue than I do. Because judges are human beings. I know it's true. Judges are actually human beings. I know we've been lying to you all this time and trying to tell you that judges are just big black robes of not human, but they're human beings. And human beings think about things different ways and they look at things different way. And if I'm looking at this from an appellate posture, the question is, can I see a path for the judge to get to where he wants to be? And the answer is under 404, probably. Yeah. To find clear error, it has to be clear error. I mean, it has to be clear, and that's hard. Right? just because I'd come out differently, so I don't know if the issue is bias. I just think the judge is, well, to the extent it's 404, I disagree. To the extent it's 403, I think the judge is making a legal mistake. Yeah. Do you know about Alex finances? The prosecutor can't open the door that way, Mimi. The question was improper. Pierre Trago said once the prosecutors asked, do you know about Alex's finances? And he said, no, all questions about finances were improper. Do you agree? I think the question was improper in the first instance. I don't think that question was proper at all. The prosecution is on direct. The fact that it's called redirect is meaningless. It's direct. It's just direct phase 2, electric boogaloo. It's just direct again. It's a more limited direct, or at least it's supposed to be. It's only supposed to be direct as to stuff that was brought up in cross, but, okay, we're doing whatever we're doing there. But it's direct phase 2. So I think the question was improper in the first instance. There's no foundation for the question to this witness. The question was improper as to that witness. That question may be a proper question as to some other witness. It was not a proper question to that witness, in my humble opinion. And this is one of the things you have to think about also as a judge and also just as a lawyer generally. You have to remember that just because a question is or is not proper for one reason doesn't mean it is or is not proper for another reason. Just because I can or cannot ask it of this witness doesn't mean I can't or cannot ask it of a different witness, right? So each of these things have to be assessed under the rules, and the determination can change. So I thought it was improper yesterday, in my view. What I don't want you to understand, because I think people misunderstand this sometimes, what I don't want you to understand is if I say, okay, that question was improper, and then, 2 days later, the prosecution asked the exact same question. I'm like, oh, that's a proper question. Well, I thought you said it was improper 2 days ago. Well, 2 days ago, it was an improper question, but blah, da, 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 da. Right? So that's the kind of thing I'm trying to avoid by giving you a more careful answer. Right? That's the thing I'm trying to avoid. So... Yeah, I agree with you, Shirori. That's why I said in principle, right? In principle, the redirect should be limited to the scope of the cross. In reality, it appears, let me just ask any question I want again. Which, okay, well, fine. Defense did the wrong objection. Well, I think the judge said that their basis of their objection was bullshit, because I think the judge said, well, your objection was based on a non-legal basis. Because I think the judge said something along the lines this morning of, your objection was, that's outrageous. And the judge said, that's not a legal basis. So yeah, the defense's objection might have been shit. But I think it was an improper question. Did the defense properly object? Probably not. No. Also, the defense didn't object early enough. They didn't, yeah. So, you gotta say the right thing. Assumed facts not in evidence, I think, is the best one, Deidre. Yeah, I tend to agree. Assumes facts not in evidence. That was probably the best objection. I think the prosecution, if you're asking me, I see you, does the prosecution have the opening to rebut loving father? Yes, I think they could have done that if they had had specific things with respect to that particular issue. So, again, that's how I would parse it, right? The question, and we can go back to 404 because they're on break. We'll go back to the rule real fast. And just go back to the law. Going back to the law is always a good place to go when you're trying to answer these questions. Go back to the words on the page. The words on the page are somewhat important, right? So, okay. So first of all, so if we're talking about opening the door, we're thinking 404A1, right? Okay. So Evidence. So let's start with the general rule. Evidence of a person's character or trait of character is not admissible for the purpose of proving action in conformity therewith. If it's for some other purpose, then we're in B. If it's for the purpose of proving conformity, we're in A. So first of all, what purpose are you offering it for? Are you offering it for the purpose of proving conformity? If you're there, then you can't do that unless, among other things, evidence of the pertinent trait or evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same. These are how I'm parsing this, right? These are how I'm parsing it. Pertinent trait of character. The same. Pertinent trait of character. Okay, so if the question is basically, in so many words, did the defense elucidate information as to him being a loving father? Sure, fine. So the pertinent trait of character, therefore, is he a loving father? Can the prosecution offer evidence with respect to that issue? With respect to that issue, yes, because it's the same pertinent trait. So to the extent that they have information about him not being such a loving father, then fine. Maybe. Okay. To the extent we'd like to talk about the financial crimes, not so much. Not so much, right? Because these are the words matter. The words matter on the page. All right, but that's only if we want to talk about the defense opening the door or not. But we can get past all that if we want to not do it for that reason. Then we go into B. It may, however, be admissible to show motive. And then the question is, well, and the question apparently in South Carolina, the way he says it is, okay, as to these other crimes, wrongs, or other acts, can you prove it clear and convincing? And do you have a logical tie that ties it to the crime? Seems to be the way that South Carolina treats that. And like, okay, then, fine. But we don't have that yet. And in any case, I'm going to admit it under 403 doesn't make any goddamn sense. So that's all that shit. But that's how I parse it. That's how I parse it. He says the door was open under 403. Yes, he sure did say that, and then goddamn sense. That doesn't make any goddamn sense. They opened the door under 403. What the hell are you talking about? What do you mean?
The jury is present, sir.
All right, thank you. Good morning. Welcome back. Day number 9. State's case. You may call your next witness.
Thank you. State call Heidi Galore.
Just a quite quick reminder to please share this link, and I'll send out the link to a couple people this morning just to see if anyone wants to pop in.
Please take a seat in the witness stand. State your name again for the record. Spell your last name, please.
Who you?
My name is Heidi Galore. Last name is spelled Galore.
Okay, Heidi. Hopefully you're going to speak a little louder. This is going to be a really painful day for us all.
Where do you work?
Morning. I work for SNAP Incorporated.
What are your duties there?
I'm a law enforcement operations lead, so I assist with and help manage a team of folks who respond to law enforcement legal process. Sure. Our team responds to legal process submitted to our company, subpoenas, search warrants, that kind of thing.
All right. So you're in charge of responding to search warrants or subpoenas from law enforcement or other legal entities?
Correct.
All right. And briefly, please, what is Snapchat?
Yeah, this is the Snapchat.
It's an application.
That's who this is. This is the keeper of records
created
for
by Snap Incorporated.
Snapchat. That's exactly who this is.
People
I'm just
express
looking for a
themselves.
name on the witness list.
People can connect to their friends, people they know, and I guess you could consider it a social networking type of application.
Is social media another word that could be used for Snapchat?
Yes.
Does it give the ability for individuals to send each other messages?
Yes.
Does it give the ability for individuals to send each other pictures or videos?
Yeah, find her on the
Yes.
witness list. I hate it when this happens.
And in the normal course of its business, does Snapchat keep records if the user so chooses?
I'm trying to find her
Yes.
goddamn name.
What kind of records does Snapchat keep?
Basic subscriber information, content that was sent to and from folks, IP logs, geolocation, depending on the settings of the user.
Okay.
All right, I'll just do it this way because I can't find her name right now.
Marked as States Exhibit 305 and 304. I'm going to ask if you recognize these two items.
I do.
There we go.
And what are you holding?
The paper here is the basic subscriber information for the user that was produced in the search warrant.
And what's that CD?
The CD contains the full production of files that was sent to your agency, requested from the search warrant.
All right. And that was a search warrant from SLED
Yes,
that Snapchat responded to?
correct.
Okay. And you said there was subscriber information on that piece of paper, correct?
Yes,
And is that also located on the CD in a digital record?
yes, yes.
And, Your Honor, at this time, state we move these into evidence.
No objection, Your Honor.
They're admitted without objection.
I'm going to hand you back States 304. And you indicated that was subscriber information, is that correct?
Correct.
And can you read for the jury the subscriber information for the information on the account that you provided in response to the search warrant?
Sure. The username is listed here. The username is listed here as Paul9499. Common spelling for Paul. The email address listed here is Paul Murdaugh 7845@gmail.com.
don't think
This
your
was
name's on the
created.
witness
The
list.
account was created on Saturday, May 18th, 2013. There's a creation IP, but it's not listed here.
I'm keeping her as keeper of records.
Sometimes it's captured at the time of creation of the account. This case, it doesn't seem to be. Phone number listed here is 803-842-7845. Display name is listed as Paul Murdaugh, and the status is active.
Okay. And when somebody uses a telephone number, for example, to create a
Her name is
Snapchat
not on the
account,
witness
does
list. That's
Snapchat
great.
verify
That's
that
just
number?
fantastic. That's great news.
If the user wants to verify the phone number, yes, they can, but it's not required.
Okay. And what about the email? Is that required?
Not required either, no.
All right. I'm going to hand you State's Exhibit 306. This is already in evidence. And I believe this is a CD. Do you recognize that CD?
Yes, I do.
And have you reviewed the contents of that CD?
Yes, I have.
And what is on the contents of that CD?
It's a video of a subject near a tree, and it's a short video with some audio.
Okay. And did that video, was that part of the full search warrant return that we just talked about?
Yes.
All right. And did you take a look at that video and the records contained in the other CD to determine when that video was first uploaded and first sent?
Yes.
Okay. Well, first of all, let's talk about the upload. Was it uploaded to something called Memories?
Yes.
And can you describe to the jury what is Memories? What does that function with Snapchat?
Memories is kind of like a bucket where you can save your data. You can either create a video or some sort of photo on the app itself and save it to your memories so that it's always there when you need it, or you can upload from your camera, your phone, into Memories to then send to folks later, or just have it in there.
So is that a form of saving, like saving something in the cloud?
Correct, yes, it'll be on the server.
All right. And in reviewing these records, did you determine when this account uploaded that particular video to Memories?
Yes, this video was first seen on Memories on June 7th, 2021 at 7:39 hours
Okay.
Eastern.
And does Snapchat also keep a record when an individual sends out a communication?
Yes.
And did you determine, reviewing the records, whether, that account sent out that particular video?
Yes, it was sent on the same day, June 7th, 2021, at 7:56 hours Eastern Time.
All right, thank you. And I'm going to show you, if you look at your monitor in front of you, and I'm going to show you State's Exhibit 306, and see if you recognize it. And did you recognize that video?
That didn't show up on the,
Oh, I'm sorry. Can we get the?
All right, I just sent the link to the stream to like 8 different creators, so hopefully some of them will join. We'll see.
Okay. What's going on now?
If she's not on the witness list, she doesn't get a name. She's not cool enough for a name. She doesn't get a name. She's not on the witness list. We'll just know. We will know her in our hearts as keeper of records.
Try it again. Sorry about that. Can you see the what's on your screen right now?
yes.
All right. And I'm gonna play that one more time. Okay. And do you recognize that video, man?
Yes, I do.
All right. And is that video?
By the way, how are the volume levels? Is my volume good? The court might be a little soft. It's already
Yes.
maxed out. So how are we doing this
Just
morning?
testified was uploaded at 7:39 p.m. and sent at 7:56 p.m.
Yes.
No further questions.
Wow, great. I mean, we just need her to authenticate the video record, so that's her sole reason for being there, is authenticating this video. So fine. You don't need much more than that.
Morning.
Can we pull up the Snapchat video, just have it frozen on a screenshot?
Yeah.
I think it's plugged into this computer. All right, that's good. So this is what, or part of what Snapchat gave to the state on July 6th, of 2021. Is that correct?
Correct.
So the state had this on July 6, 2021, in the state's possession,
I believe so, yes.
this information. And you testified that this was uploaded at 7:39 p.m. on the 7th of June, correct?
Correct.
Is that exactly when this video was shot?
I can't tell that information from the production.
Are you certain that's not something that could be told from the, perhaps the metadata for the video file?
There was no metadata produced for this production. It wasn't requested, so it wasn't produced.
So if someone were to right-click on this video file and you know, where it has various metadata that pops up on the screen, would we see a media created date?
I don't know.
Well,
I wouldn't know.
let's see if we would.
You don't know as the keeper of the records?
For a moment.
Bullshit. I have no idea if you right-click on the video if it'll show metadata for the video. I'm only the person that keeps the records for Snapshot. It's not like
Can
I'm
you see on the
familiar with how
screen,
the app
the
works.
metadata for this file?
Yes.
Does it say June the 7th, 2021 at 7:38 p.m.?
Yes.
And so this was shot basically a minute before it was uploaded, is that correct?
It appears so, yeah.
And I'm sorry if that seems picky, but in this case, you know, every minute and every second, you know, can matter. Does Snapchat keep a list of, and I might be getting the terminology wrong, friends or contacts that Paul would have had on Snapchat?
Yes.
Was that list produced?
Who are you?
And why was that list not produced?
Who are
It wasn't
you?
requested in this case.
Brown suit
You
guy.
mentioned
And
earlier
why are you
geolocation
standing?
data. Was that produced?
Sit your ass
No,
down.
not in this case.
And why was that not produced?
I don't believe it was requested.
Is it possible for, I don't know how it works, for some or all of Paul's friends to have access to his location through the app?
Yes, if his settings were, if he made his settings visible, his geolocation visible to his friends, yes.
And would that information about whether that was that setting was in place to allow that? Is that something that Snapchat would have had available to produce?
I'm not sure I'm not sure about that, if you can see that it's actually turned on or off.
Was that requested?
No.
No further questions, Your Honor.
By the state.
Nothing else was here.
All right, thank you.
Thank you.
May step down.
Illuminating. Okay, so the video was shot 7:30. He's wearing different clothes in the thing, so that might be suggestive of something.
Yes, sir.
The state's next witness would be Jeannie Seconder.
Seconder, huh?
Ladies and gentlemen of the jury, there are matters that must be addressed outside of your presence. I do not know exactly how long it would take, but I do not like to have jurors sit in jury rooms just for long periods of time. So we're going to excuse you after you speak for the bailiff. We're going to take a recess with the jury while we deal with these matters. Let's see now. You all have lunch coming at what time?
It's only 10:30, man.
Nobody knows. 1 o'clock, 1:15. All right. Well, we won't need you before lunch. So if you'll go to the jury room and wait for further instructions, but we'll be having you all take a break until around that time.
Really? Is the morning session over already? Well, that's a disappointment for the stream, if so. Having just sent out all the links to all the YouTube people for the morning link, if the morning link is already over, well, don't I look like an asshole? So that's great for me personally. Thanks, Judge. That's just fantastic. My disappointment is immense and my day is ruined. So what do you guys want to talk about? If I had known about this, I would have stayed in bed until the afternoon session and just covered the, yeah. Meanwhile, off camera, yeah, some woman from Snapchat came and testified that the record was authentic. Moving on, I could have just done that as an afternoon like description, but no, here we're at. Can the jury talk about other stuff? Sure, as long as it's not the case.
Again, the state would call Jeannie Seconder.
Are we doing some sort of preliminary hearing in the middle of the trial? Really? Why? Seriously, what's going on now? And why didn't we already do this? What is happening right now? And that also means, by the way, we get to hear all of our testimony twice, potentially today.
Take a seat in the witness stand.
So that's
State your name again for
we
the
get to hear it
record.
now, and then we also get to hear it later. So if you miss it, don't worry, because you get to hear it twice.
My name is Jeannie Seckinger, Seckinger.
Ms. Seconder, how you doing today?
I'm good.
Good. Let me fix this Elmo real quick.
My disappointment is immense and my day is ruined. Welcome to litigation.
You understand we're here
The
right
ways of
now
the judge
outside
were
the
the
presence of
worst
the
part
jury
when
for
I
an in-camera
litigated.
hearing to determine the admissibility of some of your testimony.
I do.
And just very quickly, if you would, give us a little bit. I'm not going to go through all the background that I wouldn't in front of the jury unless Your Honor would like, but give us a little bit about your background and where you currently work, how that led to where you currently work.
Okay, I graduated with a BS in accounting from USC, went to work in an accounting firm for a few years, then switched to industrial at Westinghouse. And in 1999, I came to work at PMPED, which is Peters Murdaugh Parker, as a temporary bookkeeper, and that has grown over the years to the office manager, CFO, accountant, anything business and insurance and HR related.
Okay, and that's for whom?
For Peters Murdaugh Parker, Elstroth, and Dietrich.
All right, so that's PMPED?
Correct.
And that's the law firm that Alex Murdaugh used to work for?
Correct.
Does that have a different name now?
We are now a new entity that's called Parker Law Group, LLP.
All right, so just very quickly, you've already kind of said this, but go through sort of the financial side of your job duties as it existed for PMPED back in the relevant time periods.
Okay, so my financial duties are, actually I have people under me that do the day-to-day processing of checks, but my duties are to balance and reconcile accounts, provide financial statements, help with all tax documents, preparation of taxes, also prepared anything for any government census or surveys that we needed and anything HR related.
I want to ask you a little bit about the financial structure of how PMPED works, if I could. And if you could explain that a little bit. People often think of lawyers as partners, but are they called partners under the employment agreement that everyone signed?
No, we're called partners when we refer to each other as they're in the business, but for tax purposes, everybody was an owner. It was a C corporation, so everybody's shareholders. And within Peters Murdaugh Parker, every employee was a salaried employee, including the partners.
Okay. And did the employment agreement that everyone signed require
A law firm set up as
any
a C
fees
corporation.
or money generated by any
That's pretty unusual.
partner or lawyer by the firm had to go to the firm?
It did.
And explain to me how, if you're let's just call them quote partner, if you're a partner, how does the compensation work? What are the elements of compensation as it worked under the PMPED structure back in 2021 and prior?
So every partner received a base salary that they would receive in biweekly payments throughout the year. That was set at a level of about $125,000. The majority of their pay came through an end-of-the-year bonus,
Turn
which
my
is when we
volume a little
closed
bit, I
out the
guess.
books and settled on the books. And primarily, after overhead and expenses were
Turn
met,
up a
the
little bit
net
more.
profit was divided amongst those partners. And in a simplified form, it was basically distributed based on a ratio of the fees that they brought in percentage to the total.
Right. But that distribution would not take place
Check
until
1,
when?
2.
Usually the last week of December.
A little bit low.
Yes, sir.
Waters, there's distracted. Can you repeat the previous question for me?
Yes, sir. Going back to a second, Joe, we were talking a little bit about the compensation structure for PMPED as it existed
Turn down the
in
court volume a little
2021.
bit
If you could,
then.
again,
It's
explain to
still
the
unbalanced.
court how that worked. How are partners, and we're
where's
going to call
the
them
volume
loosely
level?
that term, how are they compensated?
Okay, partners are employed salaries who are paid a biweekly paycheck throughout the year with a base salary of $125,000, and at the end of the year, they received a bonus check, usually in the last week of the year, that divided up the remaining profits of the firm based upon the percentage of revenue each attorney brought into the total.
All right, so when fees came in, they're going to be attributed to a particular lawyer, and ultimately that's going to be a percentage of the total revenues, and that's going to determine their percentage of the
there it
compensation at the end of the year after all overhead is
Turn down the
paid.
court
Correct.
volume a little bit.
Is there also
Hopefully it'll be more
sort of
balanced.
7.5% fund or fee or something like, or not, or amount that's put aside?
There is. You would take the gross bonuses that are the gross fees everybody brought in, less than overhead, and once we get to that number, everybody would throw in a pot 7.5%, and that money was divided back equally among the employees. And then a new percentage was arrived at to determine how much everybody would receive of the net income.
All right, so you have to take care of overhead, right?
Yes.
And what is an overhead, just generally?
Overhead is just basically the expenses to run the business, what it costs us to advance client costs, what it costs to pay our employees, what it costs to rent the building, to provide equipment, office supplies, postage, etc.
And that's got to be accounted for, and then you got to account for this 7.5% as well, correct?
That's right.
All right, and then only after that does each partner get compensation based on their relative contribution during that year.
Correct.
Is typically the vast majority
I missed the
of
strike issue. I missed it
received
because I
by a
was
partner at
busy messing with
PMPED
someone. I
received in
missed
that
it
distribution
completely.
at
I'm
the end of
sorry.
the year?
Yes,
And when does that take place?
the last week of the year, generally speaking.
Okay. And what is the point of that goal? Why do you want to sort of clear out all the money and clear the books?
So basically, that we don't want to leave the money in there to be taxed by the corporation because it's a C Corp entity, so that the objective is to get it out to the partners and avoid double taxation.
And so because of that, is it up to each individual partner to essentially manage the bulk of their compensation that's received in one lump sum during the course of the next year?
Yes, they need a budget.
All right, let me show you what's been marked for purposes of this hearing as States 310 and see if you recognize that document.
Yes, this is the employment agreement each shareholder/partner would have signed.
Okay. And I just want to direct your attention to number 2, and if you could tell the court what that provision that's signed by all the partners says.
It says the employee accepts such employment and agrees that the employee will devote the employee's entire time and endeavor to the employer's business.
All right. And then number 3, if you could read that to the court, please.
Services for the benefit of the employer. All professional services rendered by the employer shall be rendered as an employee of the employer, and all proceeds and remuneration received therefore shall inure to the employer's benefit.
Okay. Now tell me what that means.
That means that all fees earned should come through payable to PMPD.
All right. And so if a lawyer earns fees, is it appropriate at all for those fees to go directly to the lawyer as opposed to going through the law firm?
No,
Is that a hard rule to understand?
no,
Anybody ever have a problem with that rule or not understand it?
no,
Pretty easy and hard and fast rule in that firm, correct?
that's right.
If you get the money written straight to you, what is that?
The money's taken straight to you?
Yeah.
That would be stealing it.
Stealing. All right. Please, could y'all turn the screen for me? All right. So, is that better? So, can you see that in the seconder?
Yes,
All right. So, 2 and 3 are the provisions you were just referring to.
that's correct.
No, the jury is not there. That's why it's a preliminary
Tell me
hearing. The
just a
jury's
little
not there.
bit of
Also,
your
why we're
how
looking
long have you
forward to
known
hearing
Alex?
all this again.
I've known Alex since I was in high school, so roughly 40 years,
And how long have you worked with him, or did you work with him?
about 23, 24 years since 1999.
And did he have a lucrative practice in your observation?
Yes, he did well.
Was he sometimes getting as much as 7 figures in the end of the year?
He has.
Are you familiar with what's been called the boat case?
Yes.
And tell me what your understanding of the boat case is, just generally. What was that?
Generally speaking, it was an accident that several children got in one evening where it was in Paul's, or the Murdaugh's boat. Paul was accused as the driver, and there were a lot of civil suits and some criminal proceedings going on related to that crime.
And following the boat case, is it your understanding that Paul Murdaugh was charged?
Yes.
Is it your understanding that Alex Murdaugh was civilly sued?
Yes,
And there was ongoing civil litigation at the time Paul and Maggie were murdered.
that's correct.
After the boat case happened, did you and Alec ever have any discussions about structuring fees?
We did in late May of 2021. right about the end of the month, we had some discussions
You can only
about
store so much information in the
Hirschberger.
banner
A
because the more
disbursement
information
came
I store,
through
the smaller the
that
font
He had tried to
gets
send
and
his fees to a structured
stuff
settlement.
like that. So, like,
And the conversation was
there's
that
kind of a limit on the
he had done it
information the banner
improperly,
store.
because to structure fees properly,
I
it
guess I
has
can
to be part
try.
of the release, it has to go straight from the insurance company, straight to the structured annuity place, and we would need to be told about it in our firm so we could account for it in our 7.5%. But in this particular case, Alec had sent the money directly to Forge. We discussed the fact that it would not be any tax benefit to him, and at that point in time, he said he was not really worried about the tax benefit of it. And he said he was trying to put some money in Maggie's name due to the boat wreck, and that he was trying to figure out if he was going to structure fees for the future.
Okay. Did he say he was trying to do a favor for anyone, too?
He did say he was friends with Michael Gunn, and who is the owner of, or one of the operators of Forge, and that he was going to try to put up to about $250,000 into a structure as a favor for Michael Gunn.
All right, when you say Forge, what are you talking about?
So Forge is a company that does structured annuities.
You have the full name real quick?
It's Forge Consulting.
All right, let's call it Forge Consulting.
Okay, Forge Consulting.
All right, tell me about Forge Consulting and what they are.
They're a company that will do structured annuities for clients. They'll do structured fees for attorneys. They do some wealth management. They do minor pool trust. They have several different things that they do. I think they've branched out into insurance coverage now. They provide a lot of financial tools.
Now, when you say that you had a conversation with him about him supposedly structuring fees, how did this come to your attention?
It came to my attention over the fact that a disbursement, one
You're trying
of my
to decide-
secretaries, or my assistant brought to me,
Excuse me.
that had
I'm
been
trying to
brought to her
decide
attention
the
by
issue of,
Alex secretary for
404.
paralegal
Trying
Annette
to decide,
Griswold, and came
to
and
try and
asked me if
decide
this
whether
was
or not
proper, and then came to me after
proper
the fact, and that's when I went and had
motive
conversations
evidence
with
is
Alec
what you're trying
about
to
this.
decide.
Okay. And so had the money already been paid?
Yes,
And you went to Alec and you asked, what's this about?
yes.
And he said, I'm doing what?
I'm trying to defer and put money into Maggie's name, structure some fees.
Did he tell you where that money had gone? What was your belief where that money had gone after you talked to Alec?
My belief was it had gone to Forge Consulting.
The real entity, Forge
Yes.
Consulting.
Yes.
All right. I'm going to show you just real quick what's been marked for purposes of this hearing as States 311 and see if you recognize that series. I think there's 4 documents in there.
Yes, these are the Hirschberger settlement documents, which is the case that we're talking about, with the fee that he sent as a structure.
Okay. And are there 1 or 2 in there ultimately?
There are ultimately 2. There's one that's structured to look like fee, and then the other one was structured to look like it was client's money that was being sent on the client's behalf.
Which one were you aware of at the time?
I was aware of the fee one for the $83,333.33.
All right. At the time, did you think that any money had been misappropriated or stolen, or did you just think Alec was trying to sort of divert some money because of the boat case, but not necessarily anything misappropriated at that
Right.
time?
We were not thinking about him misappropriating funds or stealing any client funds. What we were concerned about was he was trying to either defer income by leaving it in somebody's trust, or either trying to put some money into Maggie's name to avoid things for the boat accident.
And when you say we were concerned, who's concerned?
Myself and some of the partners.
Why are y'all concerned about him potentially trying to put money in a structure or in Maggie's name because of the boat case?
Well, because that would be wrong, and we did not want any part of that.
Let me put this up on the screen real quick. All right. Do you recognize this document right here?
Excuse me. Yes, that's the document that is in question with the $83,333.33 fee sent to Forge.
All right, and right there, tell me what this disbursement sheet is very quickly. Explain that to the court.
So this is where the client recovered $250,000. You can see it came from 3 different insurers, and we would take a portion of our fee. Generally, this looks like a third, and our expenses of $9,300. The Sedgwick claims would have been a lien that we were paying off, and then the $140,678.55 would have been the money dispersed between the beneficiaries of that estate.
And what is this line right here?
That would represent the fee.
All right. At this point in time, had you actually seen the check that was made out for those fees?
I don't recall if I actually looked at it at that point in time.
And normally fees, where would they go?
Normally, if fees would come to us and we would deposit them to our income account, what we call our income account.
Okay. So fees come in from somebody who pays the settlement. Where do they go initially? What account do they go in?
To the income account, the PMPD operating income account.
Okay. Fees go in there?
Yes.
All right. When a settlement comes in, where does it go?
It goes into a client trust account for the benefit of the client.
And then the portion of that is allocated for fees, it goes from the trust account to where?
To the income account.
Okay. It usually doesn't go out to Forge Consulting or anything like
No.
that? All right. After you had that conversation at Alec, at that time, did you follow up any more on the matter?
We had a couple of conversations about it in relation to when we were having some other conversations, but we didn't really readdress this again until late September, late August, early September.
Did you kind of put it on the back burner?
I did. I was, at that point, it had been done, and I was trying to figure out how we were going to account for it on our books, and just kind of had it out there as a reminder to try to see, to put in my mind later to see if anything else had been done like that, or to see if he was going to try to do that again.
After that particular event, you said that was in late May sometime?
You're right.
Did another matter come to your attention about disbursements as it related to Alex Murdaugh's practice in his business?
It did.
And tell me what that was, please.
So this was a case called the Ferris versus Mack truck case. And on a Monday, I believe it was May 24th, Annette Griswold called me and said that she had something she needed to discuss with me. I was out of the office that day in our Waldoboro office, but when I returned, we met. And when she showed me, what had happened was we received a check for our client expenses. So this case was actually dispersed by the associated attorney, which was Chris Wilson. So he sent us a check for the money that we had forwarded as client expenses, but we did not receive a fee check. And that is itself is odd generally.
And why is that odd? Why didn't that call you? Because y'all had received a fee check from Alex's best friend, Chris Wilson, but not the expense check, but not the fee check.
Right. Most of the time we receive them together. Well, Annette, when she did not receive them together, called my assistant, Nicole, to make sure we had not already received the fee, verified that we had not already received the fee, and at that point, Annette had some conversations with Vicki Lyman in Chris's office. And Vicki informed Chris that their bosses had already got the fee when the settlement was signed, which had happened in March, and this was May.
And Vicki informed Chris, or Vicki informed Annette?
Vicki informed Annette of that.
All right. So why is that a concern to you that now you're hearing the fee's already been paid?
Because now we know we don't have the check. We've never received it. So either he's got a fee, either he's got a check he hasn't turned in to us that is properly payable to PMPD, or he's received a check payable to him.
All right. And when you were considering the possibility that he perhaps received a check payable to him, aside from that being stealing, as you earlier testified to it, what's your concern then?
Saying that he's trying to hide money from the boat wreck.
Hide money from the boat wreck. All right, stand by for me.
Yeah, so this evidence is much more relevant to his financial crimes. The real legal question is not whether they can prove clear and convincing evidence, because I think they can do that. The real question is whether they can prove the logical
Show you
tie.
what's been marked as, for the purposes of this hearing, as Exhibit
That's-
312.
That's more the judgment call. Is there a sufficient logical tie?
Yes, this is the expense check that we received in the Ferris matter
Okay.
from
And
Wilson Law Group.
just quick flip
We
to
don't
it
know
and
if
just
the
tell me
state can
generally
bring in
what
the
that-
finances
what's in
yet.
that
That's
packet.
why we're having this hearing.
The rest of the packet is our deposit, which is an internal record, our client cost report, which matches that expense check. Then the rest of
jury
it,
is not
the
present
second what I'm
on the
looking
hearing
at right
tonight.
now is a check made payable to Richard Alexander Murdaugh Esquire for $192,000, and it references Ferris fees.
Okay, keep going.
Next page is the deposit, where it says Bank of America deposit only, and it looks like ACH. That looks like, it actually looks to me like Alex initials, and then it says Bank of America.
Is there a series of emails after that?
Series of emails starts with Vicki Lyman informing Annette Griswold about the fact that their bosses had received the fee back when the disbursement was signed.
All right, let me put those emails up on the screen. I believe there's no objection versus this hearing. All right. So this is email, and Annette Griswold, explain to the judge who Annette Griswold is, please.
Annette Griswold is one of Alex's primary paralegals.
Okay. And right here, this is an email that was ultimately sent to you as part of bringing this to your attention?
Yes.
All right, and what is she asking right there?
She said, why just expenses and no fee?
All right. All right, and what was the response there?
Dear friend, it is only cost because your boss and mine and Liz's got their fees once they were signed.
Okay. So, and that's informing you that Chris Wilson's office says they already got the fees.
Correct.
All right. After that, did you have a conversation with Annette what to do?
I did. I actually talked with Lee Cope. We went to Lee. Sometimes a lot of the partners are not in the office, and Lee Cope was the one who was in the office. So I went to talk to Lee about what we should do. And, of course, Annette was worried about getting, ramifications if she was wrong and didn't want to be in trouble. So Lee and I decided to take it over from there. And the course of action that we decided upon was that I would send an email to Annette requesting the disbursement, the supporting documents, and the general ledger printout from Chris Wilson's office, which is what we keep in our office.
All right, and if we go right here, is that the email you're speaking of right there?
That is
All right, what's the date on that?
May 27th.
All right, and so then what happens to that email from there if we look over to the next page?
So apparently Vicki in Chris Wilson's office was on vacation, so on June 2nd, Annette clarifies with Vicki what exactly we were looking for. And again, she asked for the full disbursement paperwork, including the disbursement sheets, expenses, supporting docs, and ledger.
All right, and you're included on that email?
I am CC'd, yes.
Okay. All right, did y'all ultimately get a response on that?
Vicki responded that she would have to send that email to Chris because she did not have privy to that information. So that was on the 2nd. The next day, Alec came into my office early and asked me why I needed that information and assured me that the money was in Chris Wilson's account and that they could get it any time.
Okay. And did y'all discuss anything further when you had that conversation?
Just that we needed to get it, or I needed proof that it was there, that it was necessary to get it. At that point, I didn't indicate to him that I thought it was missing. I was just asking for the documentation.
And that was on what day?
It was sometime in between June 2nd and June 7th.
Okay. All right. On June 7th, did the issue come back to a head?
The issue did come back to heads.
Just clear, this is June 7th, 2021.
Yes.
And how much were these fees supposed to be, did you know?
$792,000 in total.
And to this point, the firm had not received those fees, is that correct?
That's correct.
And Chris Wilson's office is saying initially, we already dispersed them.
Yes. And Chris Wilson's not saying anything to me.
Was, to your knowledge, was an inquiry made to Chris Wilson at that time?
Lee Cope, we had not inquired Chris Wilson other than requesting this information at this point in time.
All right. So tell me about June 7th. How does that go?
So on June 7th, I was going to make another run at finding out from Alec if we had the information. I went upstairs to his office is on the second floor, and he was leaning on a file cabinet outside his office. He turned and looked at me when I came up and said, "What do you need now?" And gave me a very dirty look, not a look that I'd ever received from Alec, from just kind of frustrated with me look, which made me go, "Oh, you want to know? Let's go in your office." So we went in the office and closed the door, and at that point I told him that I had reason to believe that he had received the funds himself and that I needed proof that he had not.
Received those fees himself?
Yes.
And I needed proof that they were not?
Yes.
What did he tell you?
He told me again, he assured me that the money was there and that he could get it. And at that point I said, I'm just trying to do my job, and if I don't get this paperwork and verify that with these questions, I'm not doing my job. He actually acted like he respected that, and again said that that money was there, and that he again was trying to decide what he was going to be doing with it.
And did y'all get to conclude that conversation, or just something interrupted?
We did not. He took a phone call in the middle of that conversation. That phone call was about his father who was in the hospital, that he was going to be terminal, and that there was nothing else they'd be able to do for his father. So that changed the mood of the conversation. We quit talking about business, and I immediately asked about him and his family and his dad, and we got talking as friends at that point, concern over the family. And after that, I shortly left, so it briefed and cut down the conversation.
All right. You come in there asking for proof where that money was, because you had reason to believe he took it, and then the conversation ultimately got short by the call about his father.
Yes.
Did you have a conversation later in the day with Alec?
I did. Around 4 o'clock, my phone rang, and I remember that because I had been under the impression Alec was going to leave and go to the hospital or leave to deal with his father. And around 4 o'clock, my office extension rang, and at that point, he was asking me for some information on his 401k balances, because he stated he was working on some financials for the hearing on the boat accident that was later in the week.
There was a hearing later in the week, and he was working on financials for the boat accident.
Correct.
Did that strike you as odd?
That he called and asked me?
Yeah.
No, he had asked me before. So, and I would be the one to give him the 401k, so it didn't surprise me that he's calling to ask me about that. But I was surprised that he was in the building working on it.
And why was that?
I just thought he was leaving a deal with his father.
Because that interrupted the prior conversation.
That's right.
Is that the last conversation you had with him?
It is.
When did you find out about the murders?
I initially found out through the rumor mill around 10:30 or 11 o'clock the evening of them, but I did not get confirmation until I received a text from the partner roughly 2:30 or 3 o'clock in the morning.
Were you shocked by that?
Yes.
Scared?
Yes.
Worried?
Yes.
Worried for Alec?
Worried for everybody, yes, especially Alec.
In the wake of the murders, do you know if the hearing that was later that week got canceled?
It did get canceled.
That was a hearing in the boat case where he's personally a defendant?
That's my understanding, yes.
In the wake of the boat case, did you and the partners have a discussion about what to do about getting to the bottom of these Ferris fees?
We did. We did not the week of the murders, because pretty much our office shut down the week of the murders, and then his father also passing away. But when we got back around to it, Lee and Mark Ball and I were the ones doing the discussion. Lee decided that he would call Chris Wilson himself directly and try to get the information, and Lee took over from there.
In the wake of the murders, did anyone want to bring that up to Alec again?
No, nobody wanted. Alec was distraught and upset and not in the office much, and nobody wanted to harass him about nothing that we thought was really missing. We had several months till the end of the year to clear it up, so we were not going to harass him at that point in time.
So that part just got stopped in its tracks, is that true?
Yes, Lee took over calling Chris Wilson and trying to pursue it.
All right, and when was that? You said in July sometime?
Yes, probably early July.
All right, and what was the result of that?
Lee said, and you could speak to him more clearly, but Lee said Chris Wilson got off the phone pretty quick with him, which was surprising because apparently Chris Wilson has the gift of gab. But again, Chris assured Lee that it was there.
All right. Ultimately, did y'all get an email about this particular issue?
We did. Ultimately, on July 19th, there was an email from Chris to Alec stating that the money was in Chris Wilson's trust and would have been available anytime that we requested it. That email was forwarded to Lee Cope and myself.
From whom?
From Alec.
And what is that the email up on the screen that you're talking about right now?
It is.
All right. And we see $600,000 for Andrew Ferris and $192 for Denise. Explain that breakdown, if you would, please.
So there's two parties in this case, and apparently there was two recoveries, and each of them would have had a fee dependent upon their recovery. So to me, this looks like Andrew's portion, the fee for his settlement was the $600,000, and Denise's was $192,000.
At this point in time, had the firm received this $792,000?
No.
Did this email, though, sort of end the inquiry, at least for the present moment?
Yes.
All right, well, let's move the story forward again. Did this matter ever come to your attention again at a later time?
Yes.
All right, and tell me when that came to your attention.
That would have been in September, after we found some other misappropriations, and we had confronted Alec, and he had resigned. We ended up having more conversations with Chris Wilson right after that, and Chris admitted that he did not have all the money.
Well, let me back it up. Before we get to there, I'm talking about as far as it relates to Alec. Did this particular issue with trying to get the Ferris fees come to your attention? And let me take you to early September of 2021.
No, not that I recall.
Okay. In early September 2021, did the Hirschberger matter that you mentioned earlier, did that come back to your attention?
That came back to my attention. I started pursuing that and decided I was going to go through and look and make sure that he had not tried to already defer something else that we had missed. And at that point, I decided to print a ledger printout of our system of payments to Forge. And as I did that, I started printing all the documents that would relate to those disbursements, the disbursement statements and the canceled checks. And as I started printing the canceled checks off, I could see Bank of America on the back and Alex Murdaugh's signature. And everyone that came out was just put it a little bit more in the grave for me. That's when I found that out. I had William Barnes come over, who was a partner who was in there in the office that day, and had him look at them. He also believed that they were Alex signatures on the back of these checks.
All right, and just real quick, these are checks coming from the client trust account?
Yes.
And they're made out to what?
Forge.
But what's unusual to you that's causing you to have that feeling that you just described?
The endorsement and the Bank of America on the back, and the fact that it looked like Alex's signature.
Okay. All right. And so you talked to William Barnes, is that right?
Yes.
And did you talk to other partners about what you were finding?
We did. William and I then called Mark Ball, who had been aware of this situation the whole time. Mark Ball was the treasurer, so he came back into the office. We showed him the signatures. He agreed with us, and he also recognized one of the disbursements as a case that could not have possibly been dispersed yet because it was held up waiting some court orders for a workers' comp lien. We also talked to Lee Cope that night about it, and Lee, we came to the plan for Lee to call Michael Gunn with Forge and see if they had banked at Bank of America. And Michael Gunn confirmed that they had not banked at Bank of America in a number of years.
Did y'all send them a list of clients, the ones that you were pulling off of your system that had payments to Forge at Bank of America?
We did. We gave him a few names that evening, not the complete list. We gave him a few names that we had, and he verified that those Michael Gunn verified to Lee Cope that those were not any structures or any annuities, and they didn't have records of them.
All right. Around this time, did Annette bring you anything, and that this is all going on?
Yes, so this is completely independent and coincidental. Annette, the same afternoon of September 2nd, was in his office trying to look for something, and when she moved to file, a check fell out. When the check fell out, she looked down, and it was Chris Wilson, and it was the $225,000 check payable to Richard Alexander Murdaugh that we'd already found.
Uh-oh.
And I'm going to show you what's been marked as Exhibit 313, states for purposes of this hearing. You recognize that?
That's the check.
This is the actual check that was found, is that right?
That's correct.
Uh-oh. Well, the financial fraud stuff is looking a lot better.
It's got an endorsement on the back. Let me ask you this. You've worked with Alex Murdaugh for how long?
23 years, roughly.
During that time, did you become familiar with his handwriting?
Yes.
Can you recognize it when you see it?
Yes.
Looking at the handwriting, the endorsement on the back of that document, do you recognize it?
That's his signature.
Is his writing?
Yep.
What are
I'll do it.
Copies of these various exhibits for the court.
Yes, sir.
That sound like lurch? I'm not sure what that means, but okay, thank you. The check was client money that was paid payable to him, which he apparently kept the check around in the office, which seems like a really bad plan, but okay. I mean, yeah. So at this point, the state has half the equation, at least in my mind. They've got the clear and convincing evidence, in my opinion. So they got half the equation to bring
Right, if
this
you'll just give me
evidence
1
in.
second,
Now
I'll
they-
hand
now they-
the exhibits we're talking
The
about.
only
up to
question
court
still
as
is,
well. But up on the screen
is it
this
logically
check.
tied?
Yes.
Is there enough
Yes.
to tie it?
And then on the back, whose writing is that?
Alex.
Right? Because it has to have a tie, right? We can't bring it in unless it's relevant to this case. So you got, it happened.
Once you started printing out all those
Now the
forged
question is it tied
ones
to
that
this
had
case?
Alex writing on it in Bank of
In my
America,
mind,
and
that's
you
the
contacted Forge. Did you ask them whether or not they ever banked the real Forge, if they ever banked a Bank of America?
How's it tie the murder?
Lee Cope had that conversation, and Michael
that's
Gunn
the part that I
verified
feel
that
is a
they had
little
not
weak,
banked
though.
there in a
How's it
number
tie
of
the murder?
years,
That's a little
more than
weak.
10 years.
And they didn't have any active structures on any of the clients that y'all had given them.
That's correct.
As a result of that, what did the leadership at the firm do next?
We convened a meeting on the morning of Friday, September 3rd at Lee Cope's house with the majority of the partners and myself present. We discussed what we had found and showed everybody the documentation that we had recovered. And then the choice was made. Randy was not present initially. The choice was made to bring Randy in and show him what we had found.
And after Randy was brought in and showed what was found, what happened next?
Randy immediately conceded that we needed to talk to Alec, that it looked like he had stolen. And Danny and Randy got together and met with Alec outside of the office.
Okay. And did they confront him with this information?
They did, and it is my understanding that Alec admitted it and that it was determined he would resign.
Okay.
So he
Did ask for
admitted
a
to
leave of
somebody the
absence?
financial fraud.
I think he tried to do a few
Which,
other
again,
things
would make
before
clear and convincing
resigning,
evidence.
but we made him resign.
After the decision was made to resign, was it announced right away, or was there any statement put out or anything like that right away?
It was not announced right away because the decision was made. Johnny Parker was getting married the next day, and it was late on a Friday, and that we were going to kind of hold off until the first of the week. We were going to contact some ethics attorneys and see what we needed to do and announce it the first of the week.
Yeah, the civil suits.
So we're in the
report
weekend,
was
September 3rd, September 4th, something like that?
Yes,
It would
Is that
just be
Labor Day
against Paul's
weekend?
estate.
yes.
What's the next thing you recall hearing about Ellen?
The next thing I heard about Alec was, I was actually with my family on the sandbar, and the next thing I heard was Suzanne Peoples with the EMS came down and told me that Alec had been shot in the head and was being flown out to Savannah.
Was that on the side of the road at Old Salcahatchee?
That's correct.
What's the first thing you thought when you heard he had been shot?
You know, nobody knew what to think. A lot of thoughts went through, but fear went through. Was this retaliation? Was he involved in something bigger that was going to get more of us in trouble? And just fear.
All right. As the months went on after that, did y'all continue to review your records looking for additional misappropriations?
We did. We immediately decided, once we found this out on September 2nd and had the confrontation on the 3rd, we immediately started doing a dig into our books and proactively going to look for anything. And anything that we found, we turned over to law enforcement. We also had a forensic audit from an outside firm come in and provided information from them. So this took most of September, gathering all this information and going through all of our stuff to figure out what else we had missed or what else had occurred.
You've already described the checks to the Forge account at Bank of America, which was a fake Forge account. Is that correct?
That's right.
Was there another manner in which Alex Murdaugh misappropriated money that you uncovered in your review of the firm's records as CFO?
Yes, we've
you
also
speak for
found
the
out some
membership?
payments made through Palmetto State Bank.
Okay. And generally explain how those were working.
So those were working on, some of those Russell Lafitte was the conservator on, and funds were directed to Palmetto State Bank as if they were going to be held for the beneficiary. And those checks were later converted into personal use for Alec.
All right.
And incidentally, the week after we, of the roadside shooting, when we were going stuff in Alec's office, we actually found Forge, R. Alexander Murdaugh, doing business at Forge bank statements in his office.
Okay, so you found the Bank of America bank statements?
Yes.
And the title on those bank statements was what?
R. Alexander Murdaugh, doing business as Forge.
Uh-oh.
I'm going to get a document marked, if I could, real quick. Do the client trust account checks, what color are they?
Green.
All right. And the operating checks, are they a different color?
Blue.
Your Honor, 314 for this hearing, this will be the spreadsheet that's in one of the folders in the packet I just gave you. It starts at the top, the check date 12/26/18. And I'm going to show you what's been marked as states 314 for this hearing and see if you recognize that document.
Yes, this is a spreadsheet that we've developed of the money and the clients that had money stolen using the Forge payment method.
All right. And by the Forge payment method, you mean what?
Basically checks payable to Forge that looked like they were going to be for a structured annuity on the behalf of the client.
All right. And again, for the purposes of this hearing, in preparing that chart, you've been keeping a chart and keeping these records. Is that correct?
That's right.
Is this all the misappropriations, or is this focused just on some for purposes of a particular category?
This is just for purposes of this particular category.
And what category is that again?
Forge.
All right.
I think the question is still the tie to this case is a little weak for my
All right, I'm
mind.
going to put this up on the screen.
The fact that The fact that she confronted him the day of the murders
And
is the best
Just
tie
real
we
quick,
have.
if you
and
could just go across and tell me
A little less
what
than
the various
ideal.
categories represent, please.
so I'm hoping there's going to be a little bit
Excuse
more.
me. The categories, if you see the column with category
Excuse
forged payment, those would be where checks were actually written to forge as if those were the beneficiary's proceeds that were being sent for a structured annuity.
Okay.
The next line where it says Barrett Boulware took insurance proceeds, this is actually a check that was payable to Barrett Boulware from Southern Fidelity Insurance. And Alec actually endorsed that check. He had power of attorney on that file. He actually endorsed that check, and later we were able to trace it into his personal accounts.
All right.
If you keep going down, the majority of these are forged payment. If you get to Dion Martin, the first line says fake.
Just real quick, I'm sorry to interrupt you. Just going across, though, we've got the client, we've got the civil action number, we've got the category that you were just describing, we got the date the trust was funded, and then we have the amount. Is that
That's
correct?
right.
And the date the trust was funded, what does that category refer to?
That refers to when we found out and did the deep dive into exactly what had happened on each file and deposited the money back immediately into our client trust. So that's the firm actually, as we found these, put money in client trust. We then met with all the clients, reestablished what the correct disbursements should have been, and returned all funds to the clients.
So the firm had to pay the money back that you've determined in each one of these cases that Alex Murdaugh misappropriated through the fake forge on this list.
We did.
Just a little reminder to please retweet the pinned comment if you haven't already done so. We have a new
What's the,
tweet for
total
every
amount
session, so if you haven't already hit that
on the sheet?
retweet,
$2,841,512.55.
share it to your social media of choice.
And
if you
again,
don't
does
have
this
social
represent
media,
everything or just
call
a
a friend or
particular
something?
category?
I don't
Just a
know.
particular category.
I love you all.
Just real quick, I see that says 12911 for Thomas Moore. Is that supposed to be 21?
Yes. And that would be the date and the check number of the check that was taken.
I'm going to hand Exhibit 314 up to you. And if you could correct that with my pen here, and then just put your initials next to it, please.
Feel free to go into Law and Crimes chat and try to siphon people away. That would be fun. Until you
Going back
get
to
banned or
Exhibit
something.
314,
Why
if we
not?
look
Go
at
nuts.
all the check dates on here, we have the earliest one being about August of 2015. Is that correct?
That's right.
And then it continues all the way up to early 2021. Is that correct?
That's correct.
They boot you. I was doing it earlier. I bet they will boot you eventually. Yeah. Yeah. I appreciate the effort, though. Can the defense object? Strictly speaking, yes, they could, but it's a preliminary hearing, so. Yeah.
Along with your spreadsheet that was just marked, have you also prepared some supporting documentation for each one of those transactions of misappropriation that you've identified?
Yes, we
Actually,
have.
criminals joining us.
And these are from the records and your investigation
Sure,
into
hey,
the
Don.
records at the firm?
That's correct.
And each one of these, has the firm had to make the clients whole because of the defendant's misappropriation?
We did.
All right, I'm going to show you what's been marked as 315, and this is
this a proffer or in front of the
case is
jury?
Elise Mallory.
The jury is not
Just as an
present.
example.
This is just to
and
figure out whether or not we can offer this wonderful,
See
wonderful.
if you recognize that
notice of-
document.
Indeed,
good.
this first
That's a little
document
proper,
is
but
the
good.
disbursement, which would have been drafted at the end of the case, that states the recovery, expenses, fees.
They've got
and
half of
payments
the
to
equation,
clients.
at least in my mind. They've got the
Next, we
clear and
have,
convincing evidence.
this one actually had a payment to Forge, so I
Tied to
have a
this
copy of
particular
that canceled
offense, that
check.
was a little weak for my
And
case.
then the third and fourth pages are where we did our correcting disbursements with footnotes about what had happened and explained everything to our clients when we reimbursed them.
Okay. Let's put that up on the screen real quick. And are there similar documents, supporting documents for each one of these transactions that's on your spreadsheet?
There is.
All right. So this is a disbursement sheet, is that right?
That's correct.
And I didn't ask you, but very quickly, tell me what a disbursement sheet is and how they're supposed to work.
So disbursement sheet just shows at the conclusion of a case, once the recovery, it will show the recovery amount, list out the fees that were sent to the attorneys, shows fee splits if there's multiple attorneys, shows the amount of expenses we collect back, any liens or loans that were payable that were in the scope of that case, and then the final amount would be the payment to the client or the client's beneficiaries if they had beneficiaries.
All right. And then down here at the bottom of this particular one, do you recognize that signature?
Yes, that's Alex.
Okay. And going to the second page, what is this right here?
That is a copy of the check that was payable to Forge that you saw on the bottom line of that other disbursement, as well as the back of it showing the endorsement.
All right. And is that the real Forge or the fake Forge?
That's the fake Forge.
All right. And then what is this document right here?
This is the correcting disbursement. The yellow totals would signify what the correct amount should have been and the corrections that would needed to
Yeah,
have
so
been
there's a
made.
real company called Forge,
All right. Going back to
That
this
law
first
firm
page,
uses.
in this particular one,
and then
how
Alex
much was
Murdaugh
the
apparently
recovery?
created a fake company called Forge.
183,528
So
dollars.
he was dispersing checks to Forge.
And then was there an attorney fee taken from
So that they would look
PMPED?
legit.
There was an attorney fee taken. In this case, it was $30,000, which was a reduced fee. We generally get a third or 40%, but there are instances where the attorney will reduce their fee for
The
some
voice is still too low?
reasons.
Really?
And do you know why? Who
I could
requested
bring
the
down
fees
court
be
volume
reduced in
more
this
if it were a
case?
problem.
That would be Alec would have done that.
Alec did that, and so, but those fees got paid to the firm from that recovery, correct?
They did.
All right, great. So the rest of that money went to the client, didn't it?
It did not. It actually went to the
Well,
fake
try to
Forge
speak
account where Alec stole the money from the client.
Every last bit of it.
Every bit, the
Could also bring my
152,866.
gain
That
up a little
client
bit on my
didn't
mic.
get one dime until y'all had to make it right.
That's right.
And that's similar to the
Try that,
the
see if
rest
it
of the
helps
examples
the
we
chat.
have.
It's exactly like the rest.
Been going on for years.
Yes.
So he'd been committing fraud for years against his company, and they found out, and they were confronting
Documentation
him
like
about
that
it.
for each
and
one of these,
confronted him
they're
on
in
the
the
day
packet
of
up there. I'm
murder
happy to
about
go
it.
through all of those
In addition
with
to
the
other
witness. I don't want to sell myself short if I need to. I don't know if the point for purposes of your honor is made, or if you would like me to go through each one of those. I'm happy to keep going.
Is this Mr. Griffin? Is this yours?
So you,
So it seems like he was stealing money from the client, and it seems like he was getting increasingly more brazen in a lot of ways, which of course is not atypical for many crimes, including financial crimes. People tend to start out small and work their way up, and apparently this was coming to a head because a $192,000 check was just made out to him personally. Instead of the
Show
firm.
Kurt
The
some
firm's
love
like, hey,
by
we're
leaving a
missing
tip.
like $792,000. Where is this money
Yeah.
gone?
Remember, guys,
And,
pigs get
and
fat.
then they were
hogs
doing
get
the
slaughtered.
accounting and found more stuff. And yeah, thank you for the super chat. At least it's very kind of you. So they have clear and convincing evidence that the crimes occurred.
I don't see how this ties into
Everything.
the murder, though.
is-
Yeah, and so the tie to the murder is a
Seconder?
Miss Seconder, yes.
Seconder.
little
I can do that from the spreadsheet, Your Honor. And then we're marking the supporting documentation, which I'll go ahead and mark, but I think with Ms. Seconder, we can kind of walk through each one and describe each one. while we do that. But each packet has, we've got this spreadsheet that has each one on there, and then for each one of them, we tried to minimize it down to the bare minimum. And again, this isn't even all of the misappropriation. But we've just have a few supporting documents for each one, which is the disbursement sheet, the fake forged check typically, and then the corrected disbursement sheet that the firm had to do. That's generally what each packet has, for example, like the one we last did. Is that correct, Ms. Sessions?
That's correct.
And so I can go through those quickly, and we can do that on the spreadsheet. And then we have one other category that they uncovered of manner in which he was able to misappropriate money going back to, I think, 2008, 2009, something like that.
You may proceed.
Thank you. All right.
Sorry, not you. I was yelling at someone else.
No, you're fine. So the best tie they have is that the day of the murders, she had confronted him again about this $792,000 check. It wasn't the first time he was confronted about it, but it was the last time, I suppose, she confronted him about it, because then the murders occurred. That's the best tie they've got.
We're going through that packet that was provided.
Yeah,
up there,
but they
don't-
and we're going to go in
It's
order,
still-
except for Hirschberger, which we already talked about. And so, Ms. Sechinger, can you see okay on that screen there?
Yes.
Okay, all right. I'm going to just kind of move through these as expeditiously but as accurately as we can. First one, we have this particular client, Ms. Adriana. Is that correct?
That's right.
All right, and I'm going to put 317 up on the screen, and is this the disbursement sheet for that?
That is the disbursement sheet for that, yes.
All right, and down at the bottom, do you recognize the signature where it says attorney?
That's Alex's signature.
All right, and would typically the attorneys meet with the clients and get them to sign these disbursement sheets before any disbursements were made?
Typically, we did the checks on the attorney's signature, and then the attorney met with the client and had them signed at the same time they distributed and discussed the disbursement.
Gotcha. All right, and then right here on this particular one, we have a total recovery amount of how much?
$247,500.
All right, and then the firm gets paid its fees out of that.
And again, that looks like a reduced fee of $22,000.
And what happens to the rest of the money?
The $225,073.46 went to a fake forge account that was for Alex's benefit.
All right, and is that the check right there?
That is.
Whose signature is that right there?
That's Alex.
All right, and that's 225 and change, and then you have the corrected disbursement sheet, is that correct?
That's correct.
And this is where the firm had to make good on Alex's misappropriation.
That's correct.
All right, let's move to the next one. This would be for Mr. Barrett, using the first name, is that correct?
That's right, Barrett Boulware.
All right, and just using the first name. We have this first one is the 75,193, is that right?
That is the check I discussed earlier that was payable to Barrett that Alec endorsed directly and deposited into his account.
All right, and I'm on the exhibit 318. We're going to the third page, but is this that check right here that was made out to Mr. Boulware?
That is, and that was actually found as we went through his desk after September
Love ya
3rd.
Kurt
All right,
and hey
and you
Sean.
recognize that writing right there? I can
Underscore
zoom in
hat.
if you need to.
Orange heart.
That's Alex
Thank you,
writing.
D. That's very kind of you. Appreciate your super
And-
chat.
This is the
Thank you for
deposit
joining
slip
us
went
from
along
the
with
UK.
it.
Yes,
And what's the name right there?
Alec Murdaugh.
All right, going to the next one on the list, we have this one, and the amount is $279,850.65. Is that right?
That's correct.
All right, and we're still in exhibit 318. And this is the disbursement sheet, the original disbursement sheet right there.
That's correct.
Whose signature is down at the bottom?
That's Alec Murdaugh's.
And what does that say right there?
$279,000, $850.65.
that
Payable
good?
forge.
Fake forge or real forge?
Fake.
All right, and then what is that right there?
That's the check payable to forge showing Alec signing it and endorsement on the back.
Okay. All right, let's move on to the next one. We have, this is Hirschberger. We already did that one, correct?
That's correct.
Well, yeah, we already did that one. All right, let's go on, and we did the next two. Those were those two fees that Alec told you he was structuring?
That's right.
All right, or at least this one was, correct?
That's right.
All right, let's go on to Ms. Gary. This is States 319. This is the disbursement sheet right here.
That is the initial disbursement.
Thank you to the 500 people that are
Okay.
watching.
And what
Thank
is
you
that
very,
right
very
there?
much for all of you being
Oh,
here.
excuse me, that is
Appreciate it.
not the initial, that's
We
the
can all
second
kick
one.
ass.
So there's a forged structure right there.
And also, don't forget to check out my
112.5,
guest, potentially criminal
a
as well, on
payment
his
of the
channel.
personal rep
He also
and the
kicks
amount
ass.
divvied between the beneficiaries.
Live show
That
tonight,
forged
9:30
structure
tonight.
should have been paid to the beneficiaries, and again, it was paid to the fake forged account.
All right.
You
look
see
at-
the check signed by Alec and endorsed by Alec.
All right, so that's 112.5 right there, correct?
That's right.
And then you have the corrected
I've heard you
disbursement where y'all had to
good,
make
man.
right to the clients.
That's correct.
All right. Moving on to the next
All right,
one.
you
We have
convinced
Mr.
me
I'm
he's
gonna
a
use their
thief.
first
I'm ready to
names.
move
Use
on to
that.
other
Yeah,
issues.
no, I agree. Like,
All right, Mr.
yes,
Christopher.
I
All right. And
I don't
we
know why the
have,
court-
this, you have this
I've been in
disbursement
front of
right
judges
here,
who
is
have
that
said
correct?
stop.
That's
Okay,
right.
great.
And whose signature is that right there?
Moving on to the
Thank
next
you.
problem.
And we got how much?
Oh, people said they can't hear me.
750,000.
Going to what?
Yeah, your
Fake
volume is
forge.
pretty low, and I already
Fake
have your
forge,
next
is
one
that
like that.
correct?
That's right,
And then we have the check.
that we do.
And
And they don't bring the.
who's, you recognize that on the back?
That is Alex Murdaugh's.
Okay,
Thank you,
this is
Sandra, for the gift of
$750,000.
That's correct.
All right.
Can you guys
And
hear
then
me
we
better?
have another disbursement sheet where y'all had to correct it and make it right to the client.
That's correct.
Y'all had to pay back $750,000
We did.
that Alex spent,
We
client
did.
money.
We did. He stole it.
All right, let's go to the next one. Dion Martin, we have 3 for Mr. Martin, is that correct?
That's correct.
All right, let's look at
No
that.
relation.
We have,
So you have a little new category here. You see the above where it says structured annuity directly to Michael Gunn for $500,000.
Look at Sean all wearing
and
a
then
tie,
it's offset
Mr.
by the
Sophisticated.
proceeds structured
Looking
annuity below.
respectable.
I'm doing honest
This
work
would
today.
represent like there was an
I just got done in
annuity
court.
associated with that case that had been properly structured and sent. And that resulted in there being a $200,000 fee taken on that $500,000 that should not have been taken from the client.
so just a sleight of hand with paperwork, and Alec created a phantom real $200,000 in fees from thin air.
That's right.
All right, but that's not the end of this one, is it?
No.
Okay. All right, right here on the second page, we have a disbursement to Forge, is that correct?
That's right.
And is that real Forge or fake Forge?
That's the fake forge.
How much is that one?
$338,000, $56.14.
Okay. Now, we already talked about on this list, we talked about the fake fee of $200,000 that you just mentioned.
That's right.
And we did the 338,056.
That's right.
14. Okay, let's keep going. And what's that?
That's the
Thank you
check
for
for
the
the
orange hearts in chat.
$338,000
That's always
that's
nice.
payable to the fake forge
Makes
and
me feel
endorsed
good.
by Alec.
All right.
I really
And what is
enjoy it
this
when I'm in other
disbursement
people's
sheet?
chats.
This
I try
one
to
is
stop by as
showing
many
a
other people's
structured
chats as
payment
possible
of
because I like to show them
$45,000.
love
This one
and
incidentally had
encouragement
a
and stuff
quote
like that.
attached to it.
I always love it when
and
I
it's
see
signed
the
by
orange hearts in
client.
cowboy chats.
And that also
other
went to the
people's chats. It
fake
makes me
forge
feel
account,
good.
his personal account. This is a copy of the quote from Forge.
But no Forge structure was ever
No,
materialized.
no was done. We verified none was ever done.
All right. And what is that $45,000 check?
Here's
there?
a strange
This is the
trait for a lawyer. I'm an
$45,000 check with the fake
egomaniac.
forge
Needs to be
deposited by
reaffirmed that
Alec.
he's loved
And is this the
constantly.
disbursement sheet
Yes.
where y'all had to correct
Yes,
it and make it right to the client?
Yes.
An attorney who's a prima donna. I've never heard of it before.
Yeah.
Moving on to the next one. We have Elise Mallory, and that's the one I showed you at the beginning. It is an example. Is that
That's right.
All right, so we've done that one, and that was 183,528, where he took every last dime of it. Is
That's
that correct?
right.
Somebody was asking, how does the defense cross-examine this? You don't. This is, oh, well, so what?
Yeah.
Right, the last
yeah,
one
you
I talked
don't-
about
you
was
don't as to
321.
the financial
One before that
crimes.
was 320.
You don't as to
one
that
before
aspect.
was
That's for damn
319.
sure.
We are now on
They're relevant to
322.
the case.
Let me turn the page.
Is still an open question in my mind.
Yeah.
And we have Mr. Jamian, is that correct?
That's correct.
All right, and right here, we've got a disbursement sheet, is that correct?
That's correct.
All right, and we have a forge of $90,000.
That's correct.
All right, and is that real forge or fake forge?
Fake forge.
Okay, and what is this right here, sideways?
That is the check payable to Forge, the fake Forge, and the endorsement on the back of
That's
the
such an
check.
awful fucking name for a law firm. Payment management system.
All right, and then we have an expense disbursement right there of 5541.17, is that correct?
That's correct.
And is that another amount that y'all had identified?
We
I
identified
agree with
later that
Chad.
that was
Tron's
an
walk
incorrect
color is
charge
quite
to
left
client
wing.
file, so we reimbursed
That's
that as
getting
well.
changed very quickly.
Okay, and is this that page right here?
Yes.
And what did
We're in the middle of a
Alec
remodel.
bill to the client that y'all determined was improper?
Some airfare
To where?
on a private flight. I can't recall, but I believe that one might have been down to the Keys.
To the Keys. Classic.
Did y'all have to pay that money back too in this corrected disbursement?
We did.
That was Exhibit 322. We got 333, Mr. Johnny, $95,000, is that right?
That's correct.
All right, on the first page, we have the disbursement sheet, and we have a forged line right here for $95,000.
That's correct.
And did that go to the real forge
Are
or
you
fake
currently
forge?
subscribed
Fake
to Uncivil
forge.
Law? Would you like to
Okay, we have a
subscribe?
copy of the check right
We
there.
could use
is that
another
correct?
A copy of the check and the
250
endorsement.
subscribers. Bring us to the
And
next
a copy of the
milestone.
correcting disbursement.
Y'all had to make that right to the client.
If we get
We did.
250 more
Moving on
subscribers,
to
I don't know, I'll show you some
324.
link or something.
Mr. Jordan.
I'm not sure that's
we got
related
a
incentive,
disbursement to
but
forge, is that right?
That's right,
There
for
we go.
$85,000, along with the fake check and the endorsement on the check.
Okay. And then the corrected disbursement, correct?
You missed the one for $65,000. There's two in that
You
one.
missed one.
Yep, there it is right there.
That's
Give me some
right.
more
And then the
evidence.
correcting.
You missed one.
All right.
Lol. That's fine.
So we had an 85 and a 65,000 for that one, correct?
Correct.
I think she's a little inclined to think Murdaugh has done some bad things. Like, you missed one, prosecutor.
Exhibit
Let me help you out a little
325.
bit on that one.
This is
Yeah.
Oh, dear.
now Mr. Manuel, and we have a $70,000 forge, is that correct?
That's correct.
Fake forge?
Fake forge.
Thanks
And
for
what's
your
that right
coverage
there?
on this case.
The check payable
Thank
to
you,
forge, the fake
Captain
forge, and the
Gates.
endorsement. And this is the correcting disbursement where we paid the client back that $70,000.
That's the way I'm going to choose to parse that name. Thank
Going
you
to
for
the
your
next one, we got Miss Mary, and we got a settlement proceeds to forge of 19.5 right there, is that correct?
That's correct.
And this is Exhibit 326. And did that go to real forge or fake
The
forge?
fake forge.
All right, and what is that right there?
Copies of the check, the fake forge, and the endorsement on the back by Alec.
All right.
Thank you,
And
Dee,
then
for the
the
gift
corrected
membership.
disbursement having to pay the money back
Correct.
by the firm. All right. Going on to Mr. Randy. Right here, we've got a
Thank you,
disbursement
JoJo, for the
of
gift membership.
$9,569.30.
You guys kick ass.
On Exhibit 327.
Correct.
All right, next page we have what?
By the way,
Copy
for
of
all
the
of you
check
who are
payable to the
longtime
fake
fans of
forge
the
and the
channel, Secret
endorsement by
Squirrel
Alec on the back of
has
it.
been sick
All right,
recently.
and then
She's
the,
tweeted about it. So
correction
why don't you,
disbursement.
Correct.
if you're so inclined,
Last
tweet
one
at
for
Secret
this set
Squirrel and just let her
is
know that she's in her
Exhibit
hearts and we hope she
328,
gets
and we
better
have
and is
Morris
feeling
Mack.
better and
Excuse me,
similar themes
Thomas Moore, is that
along.
correct?
That's
you know,
correct.
send
And,
send
his signature is
Secret
that right
Squirrel
there?
That is Alex.
some Twitter
And
love.
the amount
That would be a
forged
nice
of
thing to do.
$125,000, is that
Yes.
right?
Incidentally, that's a forged signature for the client. The client confirmed that when we met with them.
Do you recognize that handwriting
It appears to me to be Alex printing.
on the disbursement sheet?
Yes, sir.
All right, and then we have the fake check right there,
That's correct.
or the fake forward check, and then that's all on that one for right now, is that correct?
Well, it's partial correction. Yeah.
Okay. All right.
Thank you, JoJo, for the $10.
With things like this going on in a lot of cases that Alec had, fair amount?
Well, we found them in these several cases, and in the scope of all cases, not so much. I mean, we have a ton of volume, so this doesn't represent a large proportion of those, but this was common with them.
And that's my point, is
Yes.
that there's a large volume,
Yes.
and these are sprinkled throughout over years and years and years.
Break it out over a decade or better.
Whenever there was an opportunity, it happened.
Yes.
All right. I'm going to show you, let me get a couple more documents, Mark.
These already should be marked.
Cowboy dabbing. That's nice.
I'll stand for a moment.
We have more likes than we do people watching now. 524 likes to 520 people watching. Yeah, better than 100%. Kick ass. All right. So what we've learned from this is that we have pretty solid evidence that Alex Murdaugh was stealing from the clients for quite some time and quite large
A
amounts.
lot.
He stole lots of things from lots of monies and it's lots.
Yes, he's a very bad man.
Yeah. Which is helpful to the defense in so much as they can use it to suggest alternative suspects. Because, like, who else did it? Well,
Who had money stolen from him.
these people have some motive.
Yes.
so it can be useful to the defense.
Think of a couple 100,000 reasons.
Yeah, it's like, who else did it? Well, where do you want to start? It's a long list. Also, it could have been the Dixie Mafia, but we don't know that yet. But yeah, the thing that's still the problem under like the 404 for me in terms of motive is like, yeah, we have the clear and convincing aspect that it happened, but that it had sufficient tie to the murders is like, okay, how does it relate to this? And it's like, okay, well, you had confronted him at one other time regarding, I think, the $700,000 check like a week before or something, and then you confronted him that day, but it wasn't the first time you confronted him. And
Yeah.
it's like, okay.
There's all kinds of.
I'm going to show you what's been marked as Exhibit 320.
Thank you, Friday. I'm in love for the gift memberships. Very kind.
Proceeding, and see if you recognize that.
I do. This is a spreadsheet of the payments that were made to Palmetto State Bank and misappropriated through that method.
All right, you testified earlier that the fake forge account, the Richard Alexander Murdaugh DBA forge, started around 2015. Is that right?
That's correct.
Long crime says 82% guilty.
You cannot tell that.
But you
from
just
this
uncovered a different mechanism whereby Alex
Crime's a
Murdaugh
little,
misappropriated money from clients prior to that. Is that correct?
That's correct. Most of these took place in 2011 and 2012.
Okay. And did Alec have some particularly big cases in those years?
He did.
And what were those cases?
So he had Arthur Badger, which was against a UPS truck in Allendale where his wife was killed, and I believe a couple children hurt. There were several beneficiaries in that case. In that same wreck, well, then they had another one with Keem Pickney, who in that same wreck had a cousin in the car named Natasha Thomas.
Okay. Let's talk about the Badger case. What was the total settlement in that particular case?
In the Badger case, the total that was apportioned to Arthur Badger was $3.1 million. There was also a companion case, Donna Badger, with a good bit apportioned to it as well. I can't recall the number right here off the top of my head.
Right. But just for Arthur Badger, who was just one of the clients that Alec had, correct?
Right.
Just for Arthur Badger, what was the attorney fee that he received in that settlement?
He received $1,240,000.
The firm did.
The firm did.
But that would be ultimately on his books at the end of the year.
It would be credited to him.
$1,260,000, is that right?
$1,240,000.
Is that all the money that Alec received from that particular case once y'all did your review?
That is not.
What else did Alec take?
$1,325,000.
Another $1.325 million. Is that right?
That's right.
And how did he go about doing
Super
that?
thief. World's best
Checks were
thief.
payable to Palmetto State Bank that were then converted into personal items,
Although he's got
payments
nothing on
for
Girardi.
bank loans, payments for loans from a conservator account, payments to
That's South
Johnny
Carolina.
Parker, I believe it was, one to his father for paying back personal loans that they had given him.
And so we've got now what's been marked as Exhibit 329 up on the screen. I'll let the sirens go by.
I agree with you, Andrew. This lady is really not a fan of Alex here. She knew him for like 23 years. I think she feels a little betrayed. Yeah. Yeah.
Guess I'll just talk over him. All right, we've got on this one at the top, we have Mr. Arthur Badger, is that right?
That's right.
And we have the date, and we have the amount, which is how much?
$1,360,000, and that is because we returned the PR fee in that case as well, because the PR failed to do their job properly.
Okay. And I'm going to show you what's been marked for this hearing is 330. And is this the disbursement sheet?
Yes, sir.
And down here, we have Palmetto State Bank payment to fund structure per client request. Is that right?
That's right.
And that's the 1.325 million.
That's correct.
And did that go to the client?
No.
Knew him for 20 years, worked for him for 23. Okay, well, that's even worse.
Yeah.
I see there's an email right here. Who is that from and to, and what's the date on that? You need me to bring it to you?
So this email is from Russell to Alec. Doesn't look right.
Who hasn't embezzled from their friends, though? Who
There
amongst us
was
is
an
not
email
guilty?
that came from Alec to Russell asking if we could recut the checks in a certain way. Then Russell independently sent an email to Alec,
I
which was
forged
forwarded
checks
to
from
me
Nick
and my
Ricada.
accounting staff, asking if we could recut the $1.3 million check into 4 different checks.
And did y'all do that?
We did.
Have any reason at all to mistrust what was going on at that time?
No.
All right. So ultimately,
And ultimately, those got broken down into all these payments. This is the payments of how these checks were written and what benefit they went to.
and they were made out to what entity?
Palmetto State Bank.
And then after they were made out to Palmetto State Bank, what happened to them?
They got converted to personal usage for Alex Murdaugh's benefit.
Yeah. The Palmetto State Bank guy has also been indicted. Is it Lafayette? I think is his name. But yeah, he's also been indicted. So that's part of the reason that they were able to hide some of this stuff, because
Oh, okay. That makes sense.
the president of the Palmetto State Bank, or maybe it was VP, but either way, he was really high up in the bank. One of the bank officers was co-conspiring with him to help hide the money. Hence the bank fraud charges, among many other things.
Real quick, I
That
see the
are currently
spreadsheet
pending.
says July 2005. I'm going to point you to this disbursement, though. What's the date on that disbursement?
November 2012.
So is that an error that needs to be corrected?
I'm sure that that's an error that needs to be corrected.
I'm going to bring your spreadsheet. Let's do that real quick.
There, it sounds like sloppy records.
I'm getting pen and
Can't understand a damn thing you say while they're talking and vice versa. I am not sure how to fix that problem, with all due respect, Mike. But we do have subtitles on screen, so we got that going for us. But I'm not sure what to do beyond that.
all right, let's talk about another case. I'm looking now at Exhibit 332, and we go back to your spreadsheet, and we have Natasha Thomas. Do you recognize that?
I do.
All right, and what was the amount on that particular one?
There were 2 payments. One was for $325,000 even. The other one was $25,245.08.
All right, and looking at Exhibit 332, we have down here at the bottom, we have payment.
But don't
that
worry,
says what
if you
entity
can't
right
hear
there?
it, not a
Palmetto
problem,
State Bank.
because you can look forward to hearing it all again
Yes.
So was a check
if
cut
this is
from the
admitted,
trust account
because
for
we're going to have to do
325?
all this
Yes.
over.
And is that
Oh,
it right there?
God, don't
That is
remind
it.
me.
And did that money go to the client?
No, that money went for Alex's benefit.
All right. Did y'all have to pay that back and make that right for his
We did pay
misappropriation?
that back.
All right.
What you're seeing now is just all the different payments that were made from that money.
Yeah, and if you don't hear it then, you can also hear it at the next trial
Those
or
were
one of the
converted at
many
the
other
bank
trials. Because
into personal
last
use for
time I
Alex.
checked, there were
That's correct.
16 other
All right, we're
pending
looking at the
indictments
second
with
check,
106 felony
for-
counts.
How much is that?
But
$25,245.08.
I can't even be sure anymore.
That's made out to what
it's a
entity?
It's a number.
Palmetto State Bank,
From the client trust account?
correct.
Did that go to the
So
client or did that go
16
somewhere else?
trials
That
currently
went
pending.
to Alex.
So that is 50
personal use
memberships
again.
towards your kilt fund.
Thank you,
And did you
JoJo. Appreciate
ultimately
it.
have to
Thank
make
you
that
for the
right?
gift
We
memberships
did.
and thank you for the super chats. You rock ass.
Last one is Mr. Hakeem, correct?
That's correct.
Is that in a companion
I
case
find it
to
hard to
Ms.
believe
Thomas?
they didn't know
It
about
is.
it for a decade. Isn't she a bookkeeper?
Got
I
two
think she failed her
misappropriations,
duty.
is that right?
That's correct.
Okay. Looking at this disbursement sheet, we have right here on the disbursement sheet, what entity
Part of the
is that?
reason that it
Palmetto
appears
State
that she
Bank.
didn't know
For how
about
much?
it was because Alex wasn't brazen at first. It appears that
$309,581.46.
he was generating
All right,
fake
and that's
fake
signed by
expenses.
Who on this?
Russell
And it
Lafitte as
appears
conservator.
that he created this fake
And
enterprise,
is that the check right there?
Forge,
That is the
which
check.
is also the
Right
name
out
of
to
a
what
real
entity?
company that they
Palmetto
use,
State Bank,
What year?
similar to J.G. Wentworth.
December
all
2011.
1877
Did that money go to
cash
the
now
client?
It did not.
and such
ultimately have to pay
that
that
does
back?
structured
We did.
settlements. So he created a fake business that uses a real business's
Finally,
name and also created fake
$60,000
expenses
for
so that they on a
PR
first
fee
glance would
again.
look
We decided
legitimate.
to pay the PR fee back.
that's
Part of the
PR
reason he
fee
was able to
right
hide
there
it.
for Mr. Lafitte, is that correct?
That's right.
The one who signed that disbursement sheet.
That's correct.
1877 cash now, yeah. It's my money. I need it now. Yeah. Yeah. You got it. Call JAG Wentworth 877 cash now. 877 cash now.
You gonna get a free sponsorship, Kurt?
That's right. This stream brought to you by JG Wentworth.
You mentioned Russell Lafitte. Do you have a relation to Russell Lafitte?
Russell Lafitte is my brother-in-law. He's married to my husband's sister.
June 7th, 2021, you came in demanding answers about those Ferris fees, correct?
That's correct.
And that conversation ended because you got a call about his father, correct?
That's correct.
And the inquiry got pushed to the side because of the tragedy of the murder of Maggie and Paul, is that correct?
That's correct.
And additionally, Alec called you about having to get finances together for a hearing in the boat case later that week, is that
If
correct?
the
That's
jury gets to
correct.
hear about all
That
this, they're
hearing got
definitely going to hate the
canceled as a
guy.
result of the tragedy of the murder of Maggie and Paul.
That's correct.
So it's one of the reasons that you want to be careful admitting it in the first place.
Ultimately, in July, y'all received an email from Chris Wilson saying the money was in the account. Is that correct?
That's correct.
What did you later find out about whether or not all that money was in the account?
We found out after September 3rd that all that money was not in the account. And Chris Wilson called us and actually wanted us to pony up the other portion of the money.
And what portion was that?
There's a couple $100,000 that was still missing.
And once,
The only
a few
phone
months
number
later,
that people
your attention
remember,
got turned back to these matters.
call
Ran that inquiry.
1-800-588-2300
That's
Empire
correct.
today.
Not further this time, Your Honor.
Mr. Griffin?
Yes, thank you, Ryan.
Do you have an idea about how long you plan to be? So we'll take a break now for about 10 minutes.
Okay. Doing break time apparently. So, yeah, I don't really I don't think the tie is particularly well established with respect to this crime.
No.
He's a thief. He'd been a thief for long. He needed money. So great, but why did the murder occur that night? The best you have is that you confronted him about this particular this check, which seems to be like the thing that was the straw that broke the camel's back and revealed the decades-long fraud, this $877,000. But it wasn't your first time confronting him. No, it was like a second time confronting him. And
yeah, that's.
I mean, presumably he thought that he would have thought that he could have bought himself additional time or something like that. So it doesn't really like why he committed the murders that night. Like, it'd be helpful if you had information that his family confronted him about it. That would be nice. But we don't have anything like that right now.
Nope.
Even if his family was generally aware, I mean, that would help a little bit too. Like if his wife was aware of money troubles and things like that. And so, but why the murder occurred, it's a little thin for my personal taste. And the problem, of course, is if you admit all this stuff and it's improper, then you're looking at a reversal, and we have to do all this over again because this is a lot of prejudice that's possible.
Yeah,
so
but remember, this judge already did some improperness by letting he let them do this, and then he said, "Oh, well, now we'll have the proffer after you drop the bomb on the jury before the end of the day." So,
yeah,
the damage has already been done, I think, to an extent.
Yeah, maybe.
Which that really pissed me off.
The one question is not going to be as prejudicial as this woman getting on the stand and being like, "Let me tell you all the reasons this guy's a thief for a half day or something."
Oh, certainly, yeah, it's even more prejudicial. But letting it into saying, "Oh, by the way, do you know he's McPoopy Pants and he steals money?" That's still something the jury's not going to unhear, and they're going to hear an uncontested.
It's a lot harder for the Court of Appeals to ignore, basically, because not only do you have to show that it prejudiced. So not only do you have to show that it was legally incorrect and that it prejudiced the defendant, you have to show that it prejudiced the defendant in a way that matters. And so if it's just like one question, like, it's just like, okay, the judge shouldn't have allowed in that one question. Are you going to get a reversal for that? No.
You should.
Because the Court of Appeals is going to say, okay, the judge shouldn't have done that, but, manifest way the evidence, blah, blah, blah.
No, the favorite one, hashtag harmless error.
You got it, exactly. Harmless error, exactly.
Which I think is bullshit.
So there's a lot easier to do that for, like, the judge screwed up a question versus the judge let in this witness who then went on for like a half day to tell the jury about how he's a super thief who steals from babies, widows, and orphans and things. That's a lot of prejudice to undo as a appellate court. So it's a pretty different posture, at least to me.
Yes, I'm inclined to agree.
Yeah. So what is the tie that ties these two things together? Why did the murder? What is his motive for committing the murder at this time? And I don't know that you have it. And I think admitting it at this time would be, if the judge admitted it on this basis, I'd be inclined to say it's error. There's not enough tie to.
Oh, I agree.
Yeah, and I would think I think it's clear error, and I think hashtag harmless error isn't going to get you past this one. So yeah,
I really would hope so, but having done this enough, I get kind of jaded that everything slips through the cracks. So,
well, I mean, you're not wrong to think that way because, as Branca says quite correctly, appeals are for losers. Mm-hmm. The overall appellate success rate is like 2% in criminal cases. And usually then you're just back to like doing the thing over again. So, if you get convicted, you're pretty hosed. Plus, he'll have already been convicted probably at that point of all the other financial crimes. And so the Court of Appeals just might not care. He'd be like, yeah, we can't be bothered to care. Yeah. So.
Yeah. Well, and it's not necessarily the appeals court, but it's so many judges just say, oh, well, I'm going to let it in. I think too many trial court judges are lax with the rules.
Yeah, that's fair. So we'll see. But if the judge allows all this in, the odds of conviction go way up, because this is a super scumbag who's just a bad, horrible person. But then the jury's convicting for the wrong reasons. So.
And that never happens.
Amelia says they're saying the motive is he had a really bad day at work. That's basically what they're saying at this point. He had a really bad day at work, and he decided, I'm going to go home. And also, like, we have video of him with his family earlier that day where he's just, it seems like he's acting completely normally. Now, it could be obviously that he is a massive sociopath who is that good at compartmentalizing and that thought out and that cold that he was putting on an act for his family with full intention of murder. It could be, of course, that he was doing it all to set it up. Oh, I couldn't have possibly done it because look how chummy we were earlier that day. So it could be that he's just a cold-blooded psychopath. But that's a lot for me. That's a lot, right? So, yeah.
There's that, and then he goes and, he does what every other guy who goes right home and kills everybody does. He takes a couple of naps during the day, and
yeah,
there's all this time in between.
I have lights. Do I not look sufficiently well lit? I thought my face looks well lit. I have a key light right in front of me. Is it not well lit? Someone said, does neither me nor Sean have lights? I have lights. Do you not like my lighting? I think it looks pretty good.
I have lights, but I'm in a corner office, and I've got light everywhere. If I turn it on, I feel like I'm sitting outside. So.
I look better now that I'm sitting up and a little closer to the light. Okay, well, sorry for leaning back in my chair there for a second.
I'm like the new Pope. I'm not going to let you see my face. Have you ever seen that show, Kurt?
What's that? I'm sorry?
You ever see the show The New Pope? It was Jude Law where he becomes it's actually pretty good. At least the first couple episodes are. And he becomes Pope, and part of his thing was he doesn't show his face to make it more
yes,
elusive.
I've heard that.
Yeah.
I enjoyed Nick Rakita's face being superimposed on images of that show. That was very entertaining. Did you not see that GIF when that was floating around with him, with his image, just his face substituted for the new Pope? It was pretty good.
Yeah, it was pretty good.
Look good, Kurt, but stop looking into my eyes. It's distracting. Music genius. How you doing? Hope you're having a great day. All right. Now that I've accomplished that goal. How's the gym going? At the moment, it's not, because I've been streaming this and I've been pretty tired. So the gym has not been going while this is happening. So that's been less than ideal. What else is coming up in your world, Sean? You got any material you'd like to pimp on your channel?
Well, yes, tonight I've got my weekly show. 9:30 tonight. Should be a lot of fun. A couple different things going on. Very interesting stories, including a lady who tried to kill her. She did kill a lookalike to try to fake her own death. So you're not allowed to kill your doppelganger, if you guys didn't know that. And then just a couple of things I'm going to keep them. There's some other interesting ones I was going to cover, keeping quiet. And then I was going to do because it actually happened in one of the jurisdictions I practice in. The police tried to falsely cite or improperly cite a guy because he wouldn't give them his ID. And I thought it's a really good example of when you could hold your ground and when you don't. So that's what I'm going to try to get released this week.
All right, cool. That sounds like a lot of fun. Yeah, sometimes the police with show us your ID and I don't wanna. Sometimes they Yeah. They generally can't require ID unless you're driving, for example, because there's no legal requirement to have ID on you. So you can't be forced to present ID because you're not required to have ID. If you're driving, obviously you're required to have ID. It's a driver's license. You're driving, so you're required to have it. If you're not driving, not so much. So you can't be forced to present what you can't be forced to present what you don't have. So, but in states where you have to identify yourself, they can only ask you to identify yourself if they suspect you of some sort of crime, and you would like give out your name and address or something, or date of birth, like basic identifying information. But sometimes police bend the rules a little. So yeah,
or they don't understand them, or they don't care. I mean, shocking for me to make that allegation, but 'tis true. Somebody asked what time zone. It's 9:30 Eastern. I'm in Ohio.
9:30 Eastern. There you go.
Yeah.
Maggie was hiring a forensic accountant to investigate their finances because the check she wrote to a charity bounced. If that happened in close proximity to the time of the murder, then that might do the trick. Like, you don't necessarily need to get in the tie from one witness. You can get it in from a combination of witnesses. So if you have information that shows that Maggie was, well, particularly that Maggie was, if you have Maggie confronting him on the day of the murder, that would be helpful. That'd be nice. That might do the trick, because at that point it's like, okay, now you have a thing that ties the financial crimes to the potential day. It's like she confronted him. If you have that would do the trick, and then at that point it goes to the jury, and at that point they convict.
Yes,
potentially for the wrong reasons, but the legal burden is met, at least in my view. So if you have that, that'd be nice.
But the fact they keep it in his bank records shows they don't. They're just going with he is a bad man. Look how bad this bad man is.
Yeah. I've done the PM thumbnail. I haven't yet scheduled the hearing for this afternoon, but I've done it. Thank you for the kind compliments on the colors. I think today I went with lilac under the counter and amber under the counter, and I'm not sure. I think it's peach is the color overhead. But yeah. It could be a family annihilator. It's possible, but again, you need something to, like, you can't just speculate that into existence. You need something that would provide evidence that would lead to that conclusion.
Yes.
So you're a fan of forest green? Well, let's see what we can do. I'm not sure how this will work. Well, let's see what we got. Okay, Google, change kitchen overhead lights to forest green.
Okay, changing 2 lights to forest green.
Okay, how's that working out for you? Do you like that? That's not actually too bad. Yeah, why is this other son alive is a pretty good question. Family annihilators tend to go out of their way to, annihilate their family.
Yes.
Yeah, I think the forest green actually does look nice. I agree. What would be nice for streaming is if there was a good pair of over the ear earphones that the band went behind the head, because I don't really like the earphones that stick in my ear. They tend to irritate my ear. It's one of the reasons I'm not wearing my hat right now, and I can't wear my hat with this earphones because the band goes over my head. So if anyone has any recommendations for good over the ear earphones that don't also go over the head, let me know.
You need to get a cowboy, not your cowboy hat, because that looks like a good one, but just get a cowboy hat where you can cut holes and just.
I don't think I'll be cutting holes in the handmade cowboy hat.
That's why you get a cheap one.
Yeah.
expensive. It's all business expense.
I could also try to get custom moldings for the in the ear ones. Maybe that would help with the irritation issues. They're nice earphones from Shure. It's the 535s. They're nice earphones. They're good quality. It's just they sit in my ear and they irritate my ear. Yeah, the lighting is not very expensive at all. The lighting is very cheap. The light that's right in front of me is it's on my Amazon page, so you can just check it. The light that's right in front of me, it's a Mount Dog. I think it's like $50. The Mount Dog comes with a color changing bulb, but it only changes in white colors. So I have replaced the bulb in there with a Philips Whiz 100-watt color changing bulb and set the bulb to a very mild green. I think it's called Screaming Green. It's very, very mild, but it's just meant to take some of the redness out of my face. So the light in front of me basically costs $70. The lighting behind me is probably the bulbs overhead are like $15 each, so that's like $30, and then the strips are like about that. So it's the entire setup, the entire lighting setup I have is like $130 or something. We work on a budget here in Uncivil Law.
Trust me, I know all about that. So, Kurt, what else do you have coming on your world coming up?
I have nothing coming up at the moment because the trial is all consuming for the moment. When the trial is over, I'm going to be trying to put out more like edited videos that are more, do a little bit more like B-roll stuff. And so I'll probably be putting up a video probably like every 2 or 3 days or something, because I'll take more time to edit them and see how that does in terms of viewership numbers and stuff like that.
Oh, okay. Right on.
And I have to do all my own editing because editors are too expensive.
I just do all my own editing because I don't want people to see how bad my videos suck before I put them out there.
Any idea why Alex was so keen to get Rogan to the scene? That's not my impression of that testimony at all. Paul had said that there was some problem with Rogan's dog's tail. Rogan's dog was being kept at the Murdaugh's kennel. Paul seemed to think that there was some problem with the dog's tail. I don't remember any testimony that implied that Alec wanted Rogan to be there. I don't remember that testimony. My guest is Sean from the channel Potentially Criminal. He does LawTube commentary as well, so you should absolutely check him out.
Well, I'm sorry, what did I miss, Kurt? What I do?
Someone asked who you were, and I was just saying.
Oh, yes.
Who you were.
Oh, thanks. Yeah, I'm an attorney out of Ohio. I'm in the Cleveland area, and I try to cover a lot of more criminal-based things, but try to cover if anything fun comes along. You can find me Potentially Criminal here on YouTube, Rumble, BitChute. I'm on Locals, Potentially Criminal. I tried working on and putting out some spicier, not for YouTube content based on the subject matter. That should be coming out as well. And like I said earlier, I do a live show every Thursday at 9:30. Try to talk about neat stuff going on in the news.
Yeah.
And this week there'll be a lot to talk about.
Excellent. I went to law school in Ohio. I went to Akron, Ohio for law school.
No shit, you did?
Yeah.
Nice. You got the Fear the Roo. Did you have all kinds of? I didn't see any kangaroo stuff in your backdrops ever. Just the Clemson stuff.
No, just the Clemson stuff.
Well, congratulations on surviving
Zips. Stupidest mascot ever.
Congratulations on surviving an Akron for 3 years.
Thanks.
That's not an easy feat. So
Akron has a good IP program, so it's got that going for it. It's also the home of the National Inventor Hall of Fame. So,
Golden Mare says, "Am I going to cover the first energy trial with the householder?" Yeah, he was the Speaker of the House for Ohio's assembly, and he got caught in a big bribery scandal, a big one. Although, I mean, the amount of the bribe he took was definitely like, if you're going to do it, you're going to do it. I don't know if it's going to be televised, Mayor. If it is, I might. It all depends. I don't know when that's actually coming up. I'm going to check.
let's see what else is happening in the world.
Oh, he's in federal court, so yeah, I can't. Oh, it's going right now. Oh. Yeah, he's down in Cincinnati. I can't do anything about that. So, and he's in federal court, so they don't.
Ooh, a game I've been following is available on Steam. Nuclear War Simulator. Fantastic. So for $30, I can simulate nuclear wars on my PC. I'm looking forward to that.
Sounds like DEF CON. Did you ever play that back?
Oh, yeah, DEF CON was a good game.
Yeah.
But this is supposed to be a lot more like realistic and photorealistic and stuff like that. So it's supposed to be more of a realistic simulation. So I'm looking forward to simulating nuclear wars on my app. It's a detailed, realistic simulation and visualization of large-scale nuclear conflicts with focus on humanitarian conflicts. It lets you design conflict scenarios and estimate the consequences using population density maps and realistic weapons effects. Ooh, exciting.
Yeah. Somebody's saying court's
Are they back? Fantastic. I've been following for a little while now.
And while you were in the midst of this conversation, he received a telephone call informing him that his father was being readmitted back to the hospital, correct?
That was my understanding, yes.
And his father had just gotten out of the hospital either that Saturday or Sunday, right?
I don't know.
Okay, and do you know that he spent the Friday night in the hospital with his dad?
I don't know.
Do you, well, his father was Randolph Murdaugh, who was one of the principals of that law firm, correct?
I know who his father was, yes.
Was he a principal of the law firm?
He was previously. He wasn't at the time of his death.
Was he beloved by the partners in the law firm?
Yes.
And his father...
Stop!
And when Alec got the phone call that his father was going back into the hospital, and you mentioned that the belief was that it was terminal.
Correct.
You stopped your work and turned into a friend, right?
That's correct.
Provided him sympathy, correct?
That's correct.
And backed off of what you were doing to allow him to whatever he was going to do with his father. Right?
That's right.
And so when you walked out of the office, things had come to a standstill as to your investigation through Alec directly.
All right, I understand.
As to where's the Ferris fee money, right?
That's right.
And Mr. Randolph Murdaugh passed away. Monday was the 7th. He passed away on the 10th, I believe, didn't he?
I'm not sure the date, but that sounds right.
That Thursday, right? And if Alec had stayed out of the office from that Monday when he got a phone call.
I'm going to take this off stream just a moment, refresh my window, because it keeps flickering. I'm going to refresh it and see if that stops the issue because it's really annoying me. It has
The
not
defense is
fixed
up
the
now,
issue.
right?
I tried.
Until the dad passed, and shortly after he passed, I mean, no one would have said a thing in that firm, would they?
I'm not sure if they would have not.
Now, what you were looking at, investigating, was where is the fee due to the law firm on the Ferris case, right?
That's right.
And that was a case.
We may play through. We may play
Alec
through the
was
break. We may play
associated with
Nuclear
Chris
War
Wilson.
Simulator. I'm looking
They
forward to
represented
people.
plaintiff, I assume, Mr.
Well.
Ferris or Miss Ferris or the state of Ferris, or,
Correct.
and they got a excellent result during the case. It was a verdict, a non-jury verdict after a trial in Richland County. You remember that?
I don't know the details of the case.
And that and you were the firm got a expense check but no fee check, and the immediate question went out to Chris Wilson's paralegal, where's the fee for the law firm, correct?
That's right.
And the paralegal said, our bosses got paid, and then that caused you to look into the matter.
That's right.
Okay. Now, and Alec told you, no, the money is still in Chris Wilson's trust account, right?
That's right.
And he said that to you on multiple occasions.
That's right.
And in fact, Chris Wilson sent an email saying the money's in my trust account
He did in July.
in July that was forwarded on to you, right?
That's right.
And I noticed, well, let me back up. Did Alec explain, did he come up with a story to explain, well, the reason the money is in the trust account is because I'm considering whether to structure the fee?
We did discuss that. Yes.
And in that law firm, your law firm that you're an employee of, partners have structured attorney's fees in the past, correct?
They have.
And so the fact that, and just so the record is clear, when we're talking about structuring attorney's fees, it is delaying the payment of the fees through some financial product. Isn't that correct?
That's right.
And by delaying the payment of the fees through a financial product, if successful, it allows to delay the payment of taxes on that money.
That's correct.
Now, in the times that the fees have been structured in the past, when the payment of the fees have been delayed, who is the beneficiary of the financial product? Is it the partner that brought the fee to the firm, or is it the law firm?
So we've only done it once or twice in the past, and when it was done, it was the beneficiary was the partner, but it was also contributed and figured into our allocation at the fee breakdown at the end of the year.
So there's no, I mean, the fact that there's a structure the time you did it, when it was disclosed above board, it is, and just use, say, a $100,000 fee, for example. I mean, to allocate it to the firm, that partner who delayed receiving $100,000 till sometime in the future would still have to put his 7.5% or her 7.5% into the kitty of the firm.
Right, and that would also be a percentage of the money that he received that'd be taken into account of that.
Well, would it? I mean, if it was $100,000,
It did.
so he got credit on, or she got credit for the $100,000, even though it never went to the firm?
Yes.
Okay. So if a partner,
If a partner did it correctly, it would be recognized and it would be accounted for correctly. The question wasn't whether he was going to structure a fee, it was whether he had received the fee personally.
understand. And he had said he had it, and it was at Chris Wilson's office.
That's what he stated.
Now, the spreadsheet and the files that you were asked about, I noticed the Ferris matter wasn't on any of them, correct?
That's right.
And the Ferris matter wasn't on any of them because the Ferris matter, the firm ultimately got paid $792,000, which was what the firm was owed on the Ferris case.
We did.
And after Maggie and Paul's murder, and after Mr. Randolph's death, murder on the 7th, Mr. Randolph Murdaugh's death on the 10th, how long of a delay was there before you got in touch with Lee Cope and Lee reached out to Chris Wilson?
There wasn't a delay in me getting in touch with Lee Cope. Lee Cope knew about it. The decision was made to call me off of it. Now Lee would deal with it from there with Chris Wilson.
Okay, so as far as you know, there was no delay. It was just taken over by Lee Cope.
There wasn't a delay on my part. It was taken over by Lee Cope.
And you don't know whether Lee, how long it took Lee Cope to reach out to
You would
Chris?
have to ask Lee.
And so, and you can't testify to that. You would have to ask Lee, right?
Yeah, I don't know.
And then you had talked about a Hirschberger case where there was actually what appeared on paper to be a structured fee, correct?
That's right.
And you're having done one in the past, it did not appear that that the proper procedures were followed so that Alec would have to pay income tax on it,
That's
whether
correct.
it's structured or not.
That's correct.
And his explanation, I think you said that was back in
Late May, early June.
Yeah, that check was May 12th, 2021, the Hirschberger.
I can't be sure when the exact conversations were. They were all going on around the same time, but it had been after that check.
Okay. And that, and so the thought there was, and Alec told you that, well, I'm just trying to sort of shelter money from me, put in Maggie's name because I'm being a defendant in the voting case.
That's correct.
Now you and your firm, and you've had outside forensic accountants looking at everything, and you don't have any information or evidence or documents that would suggest that any of the Hirschberger fee went into Maggie's name.
I did not pursue that portion of it. We have testimony from Michael Gunn that there was no annuity set up.
Right. And I guess, right. So as far as you can tell Judge Newman here today is that Alec put that money in a fake Forge account that was Alex Murdaugh doing business as Forge.
Correct.
And you don't have any information that that money then went into Maggie Murdaugh's investment account, personal account, or any sort of account, right?
I know that it went into his Forge account. After that, I don't know how it was used.
Okay. And I think you said that that you didn't start back up and looking into the Hirschberger matter until sometime in, I think you said, it did not readdress it until late September.
That's correct.
Okay. And early September, you were sitting in your office and you had a epiphany, or just a thought. Well, let's just see what how many times Alec's been his cases have checks going to Forge.
Well, when you're speaking of Epiphany, I had started digging through his client list for every fee that he had brought in, and rather than going one by one, my epiphany was, let me just run a payment ledger on Forge and see what that turns out, rather than digging one by one.
Okay. And what prompted you to do that?
Because I was trying to look to see if there had been any more settlements that had been written to Forge, like this other one with Hirschberger, so that we could account for them and discuss how we were going to handle them at the year end with the bonus distribution.
I see. And at what time of the year do you have to prepare final reports for the
December.
partners? For December? And when do you start working on that?
It depends every year, but usually December.
But in September, you were, I guess, doing your job, trying to see if there were other Hirschberger type structures out there.
That's right.
Okay. And so you ran a report of financial records that were maintained at the law firm, correct?
Correct.
These were electronic records?
Yes.
And you didn't have to order bank statements from anyone. You had them right there on your computer system?
I have mine, yes.
And there's nothing that happened well, let me back up. We've seen checks to Forge, I think you said, going back to 2015.
Correct.
Have those checks been on the firm financial system and maintained them since 2015?
They were. They didn't catch our attention before that.
Okay. And there's nothing about the murder of Maggie and Paul that prevented you from accessing that information at any point in time, is there?
No, what prevented me was work and personal obligations to get to that point in time to have the opportunity to look.
And but the information had been at your fingertips. Anything that was done in 2015, it was there. 16, it was there. 17, it was there.
That's
18.
right.
And that's why you were able to go back and do the work, and law firm stood up and made these clients whole. Is that right?
That's right.
Now, do you have the summary exhibit 314 up there?
I do not.
I may have it in here. Well, I guess I can put on Mr. Elmo here. It's not my favorite animal, but well, let me just have you look at this right quick. Can you go through exhibit 314?
I'm thinking that this
and
cross-examination is a waste of
the
time.
grand total is $2,841,500.
You're attacking her basically on whether the financial fraud occurred and or whether she's a bad accountant.
Just identify
because she should have been aware of
anyone
it earlier or something.
on this list that is just straight diversion of fees.
This is not a productive line of
due to the law
inquiry
firm.
at this time.
Both Hirschbergers were straight diversions of fees that were due.
Is there any other one on here?
That's what I'm thinking.
Partials of some of the other ones, I can't remember the breakdowns, but I know like
Your only
Elise Mallory,
illuminating question was
one of
way
those two.
earlier.
Some of them should have been firms' fees.
The only
due to
question that had value
Right.
in this entire exchange happened way earlier in the exchange, where I didn't quite see where it was going at first, and then I'm like, oh, now I get it. The reason I got it is because it removed the motivation, right? Because it's like you confronted him about it, right? Yeah, and you had this conversation where it confronted him, right? Right. I'm paraphrasing, obviously, but this is the exchange. And then the call from about the father came in, right? And then you turned into a friend, right? And then you stopped talking about the financial issue and just were a friend, right? That was the value, right? Why is it valuable? Because now he doesn't feel confronted anymore, right? He feels like, okay, because he'd already been confronted once about this issue in the past, and he obviously didn't kill his family then. He's being confronted a second time, but we've now moved on to other things completely. So why wouldn't he think he had more time? It removes the impetus, right? That's the value in it. Other than that, we've got no value from this.
And you accepted their response, rightfully so, correct?
Correct.
On this list of 314, is there anyone where you didn't go to the client or the client representative, except perhaps her?
This is a total loser right now, where he's going. Like, he's attacking her on the financial fraud aspects, which seems like a total loser, right? For this judge, like, we're in clear and convincing evidence. We're not beyond a reasonable doubt. We're there. Is her investigation a little less than thorough? Could she have done some other things? Maybe, but no, not for the purposes of this hearing. No, it's a losing line of attack. The tie issues are the issues that are meaningful, and we addressed that already. So I don't know why we're doing this at this point. I don't get it.
Permission from Barrett Boulware to keep that money personally, that perhaps Mr. Boulware had owed him some money.
When I believe Ronnie Crosby's the one who spoke with Jarrett Boulware, who is his PR, so that'd be a better suited question for Ronnie than it would be for me.
So we would need Ronnie Crosby and Jarrett Boulware to come in and testify as to what Barrett Boulware may or may not have agreed to do without.
You may have one that he could come in and testify that too, but the rest of these on these lists,
we don't
told
care
me
right
that they
now.
either did not know about it, was covered up, or
We don't
forged.
care. We don't have that evidence.
And they would need to come in and tell the
They
court.
would.
We need
And
them
they
to come
have.
in and testify. Yeah, in the
they
financial
testify?
fraud case, maybe,
They believe they have.
but
Not in this
now.
proceeding.
Not in this proceeding.
Yeah, not this proceeding is the right answer. Yeah, you know the answer. That's the right answer. That is the correct answer, not in this proceeding.
Now there was another group
Nope.
of cases that involved Palmetto State Bank, is that correct?
That's right.
And your brother-in-law?
That's right.
And again, there's Arthur Badger, Natasha Thomas, Hakeem Pinckney. Do you know if Mr. Lafitte or anyone,
The probability the
At the
judge
bank
letting
was
this in is going in
personal
is gone up
representative,
substantially, because the judge
or
is talking, because they're
conservator
talking
for-
about things that don't matter.
any of these
The
folks?
probability the judge allowing
He was conservator for Natasha Thomas. I believe he was
attacking the
conservator
fraud didn't
for
occur.
Hakeem Pinckney. I
If
can't
the
remember the
defense
exact circumstance.
continues with
And
the
he
fraud
was
didn't occur,
the conservator
the judge is
for
gonna let it in.
Arthur Badger's
It's
wife.
the wrong line of attack.
Okay. And Mr.
Thank you, Nancy,
Lafitte,
for the gift memberships.
I mean, all of these checks went to Palmetto State Bank, correct?
Correct.
And then from Palmetto State Bank, they were sent out to
Can they use it for
Pay,
impeachment in the financial
your
fraud
investigation
case?
expenses,
To the extent she testifies inconsistently.
that Alec owed.
Sure, but
Right.
do you see that
Correct.
happening? Because I
the
don't.
repayment of loans that Alec owed, right?
Correct.
And that
I
Mr.
mean, it's sworn
Lafitte
testimony, so yes, you can use
was knowledgeable about that.
You
as
can
far
use
as
it
you
to
know,
impeach her
right?
in the
Appeared to
future if
be.
she's inconsistent, but not really envisioning that scenario. So no.
Now, I want to go into
The judge is more likely
bit
to
more
say yes
detail on
than
some of these.
arguing about things that don't matter.
the
Hey, Kurt, I'm going to head out. I got to take care of some things.
All right, that's cool. Well, thank you for dropping by. Everyone check out Potentially Criminal on his channel. He kicks ass. 9:30 Eastern, tonight for his live stream. You should absolutely check that out and kick ass and subscribe over there. Thank you for dropping by, Sean. You are a scholar.
Let's just go to.
Thanks. Take care, you guys.
All right,
I'm going to put it up with Miss Elmo. And it is the Ben Allen Kendall. Well, that's Hirschberg, but let's don't do that.
The low volume compared to court. I can't get the volumes right. What do I do?
Let's do the next one, Adriana. And let's see if I can do this right. Do you see that one? That's the disbursement sheet.
Yes.
And the recovery amount here is, and it says settlement proceeds to Ford's Consulting, and that's $225,000.
Correct.
It just,
and that, according to this document, represents what the client should have gotten and didn't get.
Correct.
And then the attorney's fees here said $22,000. Is that the firm got $22,000?
the witness's husband's
Yes.
sister was married to Russell Paul
And
Murdaugh,
then-
State Bank CEO. Well, everyone's married
This
to
same
everyone in this community.
exhibit,
okay? So,
there's-
yeah, sure, she's related to literally, I'm
There's a
surprised she's
lengthy
not related to
footnote
the
down
Murdaugh.
here. I guess,
You can't just hold the fact that she's
does
related to
this
someone who's related
footnote
to
explain what happened?
Everyone's
Yes, it
related to
does.
someone.
In this footnote, it says
They
there
all know
were
each other. It's one
3
goddamn
previous
family
disbursements in
reunion.
this matter. Is that right?
Yes.
And it says the first one occurred on December 13th, 2018, issuing attorney's fees and cost, $19,932.89 to Palmetto State Bank, satisfying loans and et cetera, and other matters. Is that
Just
right?
drowning me out down to
That's
nothing.
correct.
I'll drop it a little bit.
Now, do we know if any of those are fake bills?
They look to be legitimate.
Did you confirm they
some
were
of it was legitimate.
How'd you
Okay,
do
that
that?
definitely changes the legal now.
By
Let me tell
looking at
you.
the paperwork and observing the paperwork.
Okay. And then here, there was another disbursement
Yes,
on December
South
20th,
Carolina,
2018, is that
20
right?
That's right.
I've met.
And this document referenced
I've met
some
Dick
exhibits.
That's my name tipping in the.
There's an exhibit,
I met Dick Parker.
A through F. I don't believe that's attached. I mean, it may be. I don't have it.
Oh, great.
Did you prepare this footnote?
I don't remember which ones exactly I prepared. I've prepared a lot of them, and Chelsea Vant prepared a lot of them as well.
So, and most all these have an explanation and a footnote as to what the entire transaction was
That's
about.
right.
Okay. And you didn't do every single one. It was a
They live in
team
Small
effort. I
County.
think.
Yeah, this
That's
is
right.
County's got
And so-
35,000 population.
People on the team investigated it and then would have to come here and explain exactly what they did and what they learned. And
That's correct. It's also been through forensic audit and also looked at former FBI, and it's been provided to law enforcement who all looked over it as well.
No one cares right now. Why are we into the minutia about this? Do you really think you can attack the minutia and get below clear and convincing evidence with the here is the check with his signature on it? That's a bank account that's his. Really? You think you could attack, oh, look, this might be legitimate. Oh, this wasn't investigated as well. How could you have not known about this for 20 years? Really? Seriously? You think you can get back below clear and convincing evidence by attacking the minutia? I don't think so, Ted. Yeah. The 460.
now, I think
currently
you
watch
also said that
60, by the
on
way.
back to June the 7th, that you said that Alec called you and asked for his
5,000 paper
updated
cuts.
balance in his 401k,
That's right.
and he told you he was putting together some financial
Not with
records
this burden of proof the state has
for
not
civil
right now.
discovery and the voting case. There's a hearing coming up,
Yes.
No, please.
and that he had asked you, he'd questioned you previously about the balance in the 401k,
That's right. This has not been the first time.
and the times that he questioned you, was it in context of putting together information for the voting case, or just he was curious?
Putting together information for financials.
Financials in general, or financials in voting case, or you just don't know?
I didn't really ask particulars.
Nope.
The
So,
perception was that it's for the voting case. Talking in the office, we knew hearings were coming up. We knew they were looking for his financials.
okay. Well, when you said on the 7th he called you about financials, did he reference the voting case during
I
that?
believe he did.
Okay. Now, do you know,
We've had one relevant question so far this entire
What-
exchange, basically.
impact or what consequences Alec would have suffered from his partners if he had just, or if you had found that he had diverted the Ferris fee to himself personally, as opposed to
Speculative.
putting it in a
shouldn't
structure
do that.
or
Speculation.
putting it in the firm. Do you know?
I think
No, she
that he
doesn't.
probably would have had some bad repercussions for him because they were adamant that we were not going to be part of having any portion of hiding or diverting any fees.
And the concern was hiding fees from the civil discovery in the voting case.
Yes, at that point in time it was.
And that wasn't, at that point in time, no one was saying that they thought he was stealing from the firm, but that he was sheltering money from being disclosed.
That was the opinion, yes.
Okay. But
And then it wasn't until
I don't know
September
about-
when you ran a report and you saw all these
that helps
forged
that much, but
checks being deposited
All
in
right.
Bank of America account and
nice gas.
endorsed by Alec. You'd seen his
I guess I'll
signature.
charitably give the defense a
That you
point on that
realize-
one as I'm desperately looking for hope.
Been something far different going on than what anyone believed. Is that
That's
right?
correct.
And that's what led to his resignation or termination.
Correct.
Wow.
And that information had been in the books and records of the law firm since 2015.
Correct.
Wow, that was a whole lot of nothing. So we got that. We had moved on to other topics, which was the best, and now we just got we thought that the financial fraud was relating to hiding assets, was our perception of the thing. But that doesn't really matter what their perception of the thing was, because what matters is how Alex Murdaugh perceived the question. Right? What they thought the reason was. And
One last
Alex
question.
Murdaugh thought the reason was.
The information that in part of the
No,
investigation,
their own personal
you
perspective
and members of your
of
staff
what's
and the
happening.
forensic
Not
accountants
really
determined that
helpful,
the clients did not
As I'm desperate to look for
authorize
something that
any of
helps
these
the feds, because
transactions.
That was something.
I mean, you have no
Thank you, and
personal
it's
knowledge
very, very nice super chat.
other than what's been told to you by people working for you or by the clients, right?
I also saw some of the deposits going into his personal Bank of
I
America
love you,
account
MK.
statements.
You're the best.
No, I understand that, but whether the clients,
If they had some back deal, I don't know about any of it, no.
right. And any information you have about what the clients told the firm is hearsay, as far as you know.
It's not hearsay if they said it to me.
Yes, it is.
And some said it to you.
Yes.
Okay. Thank you.
Very briefly, Your Honor.
Wow, that was mostly pointless. I think the odds of the judge letting this
One thing you
are
know
pretty high.
is that the money that you've talked about for the fake forged
went into an account Richard Alexander Murdaugh DBA forged, correct?
Correct.
Is there any possible legitimate explanation for client trust funds to go into that account?
No.
And after you realized that they went into those accounts, did the firm ultimately refund the money to those clients?
Yes.
You mentioned that you actually found in his office some bank statements for that particular account. Is that correct?
That's correct.
I'm going to show you what's been marked as Exhibit 335.
I think the judge is going to let it in because they're focusing on completely the wrong issue.
Have you take a look at it?
In my opinion.
Is that consistent with the
In my opinion, they're focusing on.
Richard Alexander Murdaugh DBA fake forge account that you saw?
Yes.
That you have repeated instances of client trust money going into?
Yes.
That there's no possible legitimate explanation for?
That's correct.
You were asked some questions about the manner of your inquiry and that sort of thing. And I want to take you back a little bit further very quickly. Do you remember, is it common for, after the books get cleared at the end of the year, for certain partners to loan money to the firm to handle operating expenses until fees start to come in?
It is. Basically, we wipe out all the cash reserves, so in order to operate for the first couple of months, attorneys will loan money to the firm for operating expenses.
At some point in time prior to all of this, did you become aware of an instance in which Alex Murdaugh had erroneously received a repayment that was actually meant for his brother, Randy?
We did.
All right. And did that happen once, or did the same thing happen twice?
It actually went through twice. The check was written to him erroneously, and within a few days, he brought the check back to my staff and had it recut to him. So the first check that was recut was held for him for about a year. So the replacement check went through immediately, and the first check cleared about a year later, and that's when we discovered that, going back and looking, that I discovered that he was paid erroneously, that it should have been Randolph Murdaugh and not R. Alexander Murdaugh.
So it was one repayment, but he managed to get it twice.
That's right.
How much was that check roughly, do you recall?
$125,000 roughly.
$125,000. Was he confronted about this when that was discovered?
Yes.
What was his explanation?
His explanation was that it was an accident, that he thought it was due to him and that he didn't know, and that he found the other one later and deposited it too because he thought they were due to him.
Okay. And was he required to pay that money back?
Yes.
And after he gave that explanation of, oops, I didn't realize these $225,000 checks were for me, was that matter then forgotten or moved on from?
It was shelved, yes.
It was shelved. Nothing, no repercussions happened at that point in time or anything like
No.
that? Okay. So the money gets paid back and people moved on. Is that right?
That's right.
Okay. You testified before that when the murders happened, that the inquiry, nobody was going to bring that up now in the wake of the murders, the Ferris fees that you had talked to Alec about the morning that Maggie and Paul were killed, correct?
That's right. It's a family-like place. Everybody was concerned for him, his family. We knew we had time to discuss this before the end of the year, and at that point, like we said, we didn't think he was stealing any money from us.
They had no reason at that time to think he was stealing, correct?
That's right.
And so it did get shelved, correct?
That's correct.
All right. And then in July, you got an email, is that correct?
That's right.
And you testified to this before. What did the email say from Chris Wilson's office?
It said that the money was in the account and available to us at any time that we would ask.
And then, so at that point, the money seemed like it was there. The money is not missing, and so the matter was shelved. Is that correct?
That's correct.
All right. However, you've testified that things have been going on for a while, and it was months later that triggered you to do that inquiry. Is that correct?
That's right.
Okay. Because there have been multiple instances over the years. Is that right?
That's right.
But that has nothing to do, the fact that might have occurred regardless of, at any point in time because of all the things that have been going on. That has nothing to do with the fact that when things were happening in June, they got shelved, and then you found out the money was there, and you thought that matter was closed. Is that correct?
That's right. We never knew about the prior. We had no reason to look. We had no complaints from clients. We had nobody saying they were missing money. And this just turned up when we started searching because of the Hirschberger and the other relevant things.
Has there ever been instances in which Alec used the firm credit card for personal expenses and was required to pay that back?
Yes,
And if the money got paid back, well, then the matter, everybody moved on. Is that right?
that's right.
So there was a history of that.
That's right.
You get the money back in, and everybody moves on. Is that
That's
correct?
right. It's a history of trust and brotherhood.
And that's what happened in July with the Ferris fees. Is that correct?
That's right.
Ooh, a little nice little
About
burn
whether or
there.
not You
I
were
like
told in
this.
July
This witness is a little pissed.
that the money was in Chris Wilson's trust account. That's what you were told. Is that correct?
Correct.
Have you come to find out, however, that it actually had not been there?
We did.
And you found this check proving it, correct?
That's correct.
So the state's basically trying to show that in the months up to it that there had been increasing concern regarding Alex Murdaugh's management of money, and trying to show that this last thing was the straw that broke the camel's back, and it was that
bottom
day,
line
the day
is-
of the murders, that he was confronted with this thing, and therefore the
Is that
tie.
there had been a long history of
And the defense
if money
did
got
F
paid
all
back,
to really
people would move on, correct?
That's right.
Address that issue in their
Things were
long,
continuing to
meandering
percolate. They got
process.
delayed in June because of everything that happened, correct?
Correct.
But you were now curious, and eventually, months later, you look back at that. Is that correct?
That's correct.
And that also was highlighted and sparked by the discovery of the check, proving that he had not been telling the truth the entire time.
Correct.
Thank you. Nothing further.
Anything further? All right, thank you. You may step down.
It's not going to end well, I don't think, for the defense here, guys. It's my prediction. I think this is not going well. Judge is about to school you, I think. Oopsies.
Well, we're running up on lunchtime. Mr. Waters, what's next?
Well, we can certainly continue with this. We have Annette Griswold, who is Alex's former paralegal, who in large measure will testify to the similar events with Thomas Moore Hirschberger and the Ferris fees. Again, I don't want to be cumulative for purposes of this, but she will certainly add to that. We also have available on this particular issue Michael Gunn, who is the principal in Forge, who of course will testify that he had never had any discussion with Alec about structuring fees, or at least nothing had ever been set up, and that this account is not his, and that all the money in these various transactions never went to him, and that they were diverted. And then we have Chris Wilson as well, who can describe the circumstances of those Ferris fees. All that would be very lengthy, but we have all that available in as much as that's necessary to complete the story for purposes of the in-camera hearing. We do have, though we have arranged to get additional SLED and other witnesses here related outside of this for the afternoon, if you wish to make use of the jury for that. And also, as it relates to this, and we're also prepared to offer testimony about these particular instances, but we do have a confession of judgment that I would offer to the court at this point in time in the Satterfield case. And again, before the jury, we would have testimony about that, but for purposes of clear and convincing evidence, we have this confession of judgment that we would offer for purposes of this hearing as well. In addition, we have his disbarment from the Supreme Court, which also refers to his admissions of financial misconduct, which we believe also are relevant to the court's decision at this point as to whether or not there is clear and convincing evidence established of these various other crimes. And so we would offer those as well to the court for its consideration.
I think clear and
now.
convincing,
However, we
I'm
can
sold.
certainly
That'd be
offer
what I'd say as
testimony
the judge
about
at
those
this point.
aspects
For the
as
purposes
well.
of this hearing,
I think,
I'm
Your Honor, if
clear
we
and
can
convincing.
get to a
All
decision
I'd want
point
is more
on the law
testimony
firm
on
witnesses,
the
then we can move
tie-in would
forward.
be the only thing I'd care about at this point.
Again, we have some witnesses
for
related to
purposes of this hearing,
Satterfield
I don't need to hear that
we
shit.
could address and
ready to move
try
on
to
to
work that in over the next few days of court time. And then finally with the boat case as well. And so that would be some of the financial witnesses that we would offer. And then finally, Your Honor, we do have some witnesses from Palmetto State Bank who will talk about the extent of Alex Murdaugh's financial condition at the time the murders happened, and the reason why, explaining the reason why all these things were occurring and why they were all coming to a head in June of 2021.
Mr. Griffin?
Your Honor, I think there's more than enough in the record from this witness to establish that this evidence is not admissible under 404B. And, I mean, without even getting to whether they can prove it up by clear and convincing evidence.
They totally did.
I'm happy to make that argument at any point in time.
No, they totally
But
did. It's a loser argument.
The whole landscape that he just talked about, Your Honor, 403 also includes a component of undue delay. And as he just described, all the financial misdeeds or crimes that he wants to prove up, we're going to be here until end of February, I suspect, or March, because that's adding 2 weeks to this trial.
Yes, sir.
Yes, sir. And obviously, as I even pointed out with this witness, we're trying to streamline the presentation. Frankly, the extent of misappropriation is very, very broad, and we're trying to focus on just a few areas. And the ones that we're focusing on are the ones that really came out of his mouth within seconds of law enforcement being on the scene, within seconds of the 911 call happening, and that is, of course, the boat case. And what does that mean? But there's two things that are very temporally connected with this particular crime, and that is the confrontation with Ms. Seckinger that morning over the fares fees that have been percolating for a while, and then number two is that pending hearing that very week in the boat case, which again, the purpose of that hearing is to, in a specific request for production and interrogatory, to identify all accounts. And again, once you do that, once those accounts are identified, just like Ms. Seckinger was able to do, just like law enforcement was able to do, the state grand jury was able to do, it doesn't take long to figure all that out and then lead to not only what's happened here, his disbarment, but also, I don't have to get into this specifically, but 99 counts for which he's facing.
The judge may have already made up his mind
on that alone. And so that kind
I
of
mind at least to some of it. So
consequence that's hanging
may
out
mind
there
just all
is
of it.
very much relevant
Just
and very timely to what was going on June the 7th in his life. The defense asked the question, can you think of any reason? And all of this going on in his life, which is a stellar series of events like nothing ever seen, is it certainly relevant for the jury to consider when they consider a perfect storm that was arriving for this man on June the 7th.
Griffin, the witnesses that are here, Ms. Griswold, Chris Wilson, and Mike, Mr. Gunn, confession of judgment and the disbarment, do you contest the matters which they are here to testify concerning?
It depends on how far they go with their testimony, but I'd certainly, that's predicate for Mr. Gunn to testify. They didn't have an account at Bank of America, and those checks were not deposited with us, and I didn't know anything about this. I mean, that we're acceptable to that, and just, without knowing the full scope of what they intend to offer, it's hard to say yes, but that's all. I mean, just like this witness, I mean, she has a lot of information that is that she learned through investigation. But if we had to try this case, 90% of it she couldn't testify to.
Your Honor, I'd point out that those witnesses that I mentioned, as well as every single one of those victims, all testified. There is transcripts on that, which the defense has had,
that one there, Counselor.
which, Your Honor has access to as well. So I don't know that necessarily it needs to all be repeated for Your Honor's determination now, because again, as he just said, those facts have been testified to. It's just a question of the parameters for this particular trial, which again, the state's intent is not to try 100 white-collar cases in the context of this murder case. It's only to explain to the jury enough of what was going on in an unfathomable set of events for a lawyer what was going on in his life that were all coming to a head on June 7th. I think that's extremely relevant, and we plan to do so in a very expedited and focused fashion.
Your Honor, I would say for purposes of the trial, going forward with the jury, I mean, we're not stipulating to any facts.
Yes, sir. Well,
For the purposes of hearing, I'm very candid with the court.
yes, sir. As far as the court's view of things and what the court needs to determine to be convinced that clear and convincing evidence exists.
It totes exists.
Clear and convincing evidence is not proof beyond a reasonable doubt and all that. It says that degree of proof which will give me a firm belief as to the facts sought to be proven. And if those specific facts are not being contested, what the communications with Ms. Griswold that's in the record, with Chris Wilson, there may be, Attorney Wilson, may be some dispute, I don't know. Mr. Gunn, Forge is a well-known consulting firm, and the Bank of America account says Richard A. Murdaugh, sole proprietor, DBA Forge. Confession of judgment, disbarment. I'm happy to sit and hear any and all of the testimony. One of the things that did occur in the Siegel case was the judge who got reversed didn't want to spend time listening and hearing all of the evidence because of the expediency of things. And the court says, although we sympathize with the court's concern about the length and complexity of the trial, we nevertheless conclude that the importance of the evidence, due to the importance of the evidence, it must be presented and the court must receive it. So I am happy to do that without needless presentation of evidence twice, more than once. And now I understand the defense's position, and I'm not seeking any waiver on the question of whether or not this should be admitted or not admitted. I know you each have your arguments on regarding 404 issues, and I haven't heard much argument on the race geste issue, which is equally important, or perhaps more important. But if you are interested in contesting the nature of each one of these witnesses' testimony, if they're here and available, we can hear them. I mean, we can. You indicate that there are some other witnesses on other matters that can occupy the jury for a bit of time this afternoon?
Yes, sir. After our discussion this morning, we got some folks rolling, and after lunch hour, I think we can take us through the end of the day with witnesses that don't relate to this specific issue.
We can go in that direction and then resume with this with more witnesses later this afternoon, tomorrow morning, tomorrow afternoon. I just don't want the jury to sit and to be in an idle format. And to the extent that you all can be in agreement with a path forward, that's best. If you can't, then I make the call.
Your Honor, as I mentioned earlier, I strongly believe that based on what you've heard thus far, it doesn't meet the elements of 404B, and you don't need to get to whether it's been proven up by clear and convincing. I mean, if you rule against us on that, then we have to.
How about res geste?
Well, the only thing that would come close to res geste is
Res geste.
Res geste.
Use geste. Go ahead.
Tomato, right? And so the only thing that comes close to that is, the encounter on June the 7th by by this witness up there about the Ferris matter. So one matter. It's the Chris Wilson co-counsel fee issue, and that was the only thing he was confronted about in the afternoon before the murders. And
the state has to prove the state of mind of the defendant, not solely what this witness knew at that moment in time, but what the defendant knew that was subject to exposure.
so, Your Honor, in the with regard to the res gestae issue, we had briefed State v. King 334 SC 504, and that is somewhat similar in that it involved thefts for someone stealing money, and there were remote thefts, and there was a theft the night before or close in time to the murders, and the claim was that the murders were done to get money from the victim, and that we had thefts earlier in the day or the day previous, and then a number of thefts months and years before.
Did the judge do the 403 analysis, 403, 404 analysis in King?
Well, the trial judge allowed it in. The Supreme Court, Justice Burnett in 1999 overturned Judge Hicks Harwell for admitting the evidence.
Without conducting a 404 analysis, 403 analysis?
Well, I mean, they have a footnote in there.
You have to do what we're doing now.
Yes, sir. But in the case, they said, while the remote thefts may have been minimally relevant to show motive under law, the prejudicial effect of this evidence far outweighed the slight probative value. So the Supreme Court did a 403 analysis, and that's in footnote 5, Your Honor.
Anything else before we break?
Definitely not.
We'll resume at, what is this? We'll resume at 2 o'clock with, at 2:15 with witnesses, and we will resume with witnesses and the jury witnesses. And we'll resume with this in-camera hearing involving witnesses later.
Yes, sir, Your Honor.
So we'll be in recess at 2:15.
Okay. So yeah, I find the judge to be very thorough in his explanations. The citations to the case law and footnotes and things like that is relevant. The judge seems to be very cognizant of the legal standards that are present. Right now, the question to my mind is not the clear and convincing evidence standard. I think you're there. The question to my mind is the tie to the crime, which is a little weak for my taste. That being said, it's a judgment call, and I don't know that I could say that it would be absurd to say that there's sufficient evidence to tie it. It's weak, but it's not non-existent. So the motive basically is, well, these financial crimes were coming to a head. He had been confronted about it once before, and he was confronted that day, and he had this hearing coming up, and because of that, in some way, he committed the murders. It would be nice if he was going to inherit money, or it'd be nice if we had evidence like that his wife confronted him that night, or things like that. People in chat have been saying that the wife was consulting a forensic accountant, but would he know that is not necessarily obvious. So the tie is weak to my mind. So that's where I think. I don't see the nexus, as Techlawyer said. I don't really see the nexus. I tend to agree with Techlawyer. For my money, I don't think the nexus is present. It's too speculative of a nexus, and it's a judgment call. But it is a judgment call, and it's not zero. And the defense didn't really do themselves any favors by their line of argument, because their line of argument was almost entirely about whether the financial crimes occurred, which was really not the most productive line of argument. I know they don't want to concede the issue and all, but the standard is clear and convincing evidence, and you're there. You're just there. And I think it's a distraction. It's a distraction. Reminds me of that J.K. Rowling quote. It's like, sometimes you have to kill your darlings. You have to let things go, even though they're like your favorite thing, because they don't serve the story or the book. You have to kill your favorite line of dialogue, or you have to kill your favorite whatever, because it just doesn't serve it, and you want to make the thing work, and you can't make it work, and you just have to let it go to ultimately serve the story. So I understand the impulse to fight for everything, for sure. I understand the defense lawyer's desire not to give anything up, but I think it was a strategic mistake in balance, because the real issue is not, can we get to clear and convincing, because we totes can. The issue is, right, and of course, at the financial crimes, when we're on a beyond a reasonable doubt standard, these lines make way more sense than they do at this stage, right? So because we're asking a different threshold question, because we're asking not beyond a reasonable doubt, but rather clear and convincing evidence, right? The lines of attack are not productive, at least in my humble opinion. The much more productive line of inquiry is the nexus, which the defense spent all time on, comparatively. So that's my sort of thought about it. Because the defense's argument is in the wrong place, it becomes easy for the judge to make the judgment, because it's like, well, defense argued not clear and convincing, but totally clear and convincing, therefore admissible, right? Because the defense didn't really attack the nexus, the judge doesn't really have to address it. And that becomes a problem also for the appellate lawyers down the road, because, well, the defense lawyers at trial are not doing a real great job of preserving the issue, right? It's not, yeah, this is not going great. So I think at the moment the judge is admitting it, and I'm not sure that that's attackable on appeal. I mean, of course you try to attack it on appeal, and you could always, of course, go to 403, which is your stopgap at the end of the day. It's like, okay, you could always go to 403 and be like, well, the judge wasn't wrong for saying it's admissible, but they were wrong for saying it wasn't substantially more prejudicial than probative to bring all that in. So, but trying to overturn a judge on a 403 issue is pretty hard, because, it's substantially more prejudicial than probative. And, it's a judgment call. And so I don't think the defense is doing themselves any great favors in setting this stuff up. Nexus is just the tie. Nexus is the connection. How are these things related? That's nexus, right? So you have these financial crimes and you have the murder. The nexus is the thing that brings them together. How are you bringing them together? What is their tie? And the tie is weak. But yeah, it's not going. I think it's just weak. And appeals are for losers. Yeah. I think the judge is inclined to admit it. I don't think that necessarily means the judge is biased. The judge seems very thoughtful. I think sometimes, and I'm not sure this is always true, but I think sometimes the chat collectively uses terms like bias just to mean it's a thing I don't like. And I'm just because I or the judge am coming to conclusions that you don't like doesn't mean that we're biased. It's judgment. It's how we assess weighting things. And the judge seems thoughtful, considerate. He's doing the proper analysis. And, that maybe it's just too uncomfortable. Maybe it's just too uncomfortable for the proposition that two different judges could come to two different conclusions and neither one is necessarily wrong. Maybe that's the problem for the collective chat. Maybe that's just something that's too uncomfortable. There is literally judgment involved. There's literally judgment involved. And it is possible for two different judges to look at the exact same thing and come to two different conclusions and neither of them to be legally wrong. At least in the sense that you'd be reviewing it from the Court of Appeals posture, right? Is this clear error or is that clear error? That I disagree with, it doesn't make it clear error. That I would have made a different judgment does not make it clear error. So it is quite possible for the judge to go either way and the judge to not be reversible because of the standards that we use. That's the law. Trial judges are given a lot of discretion, not infinite, but a lot. And just because a judge issues one decision or its exact opposite doesn't mean that either way he can be reversed, because that's the law. As a Court of Appeals judge, you have to show that he made clear legal error. And if he just assessed it differently as a matter of judgment, that doesn't make clear error. That he ignored some precedent or didn't properly apply a precedent or something, that's error. But he properly applied all the things and just came to a different conclusion than me is not error. I don't know. That's what I think. This is also why, for example, I'm very reluctant to say that, for example, if a different lawyer on the law tubes disagrees with me, it's because of bias. Like Emily D. Baker may look at things completely different than me, for example. That doesn't necessarily mean that her judgment is attackable in the sense of being like legally wrong. That I would come to a different judgment, for example, is one thing. That her judgment is legally wrong is a whole different proposition. So, this is the nature of this is the nature of the law. And so you just, I try to assess this thing. I'm wrong. You're going to appeal my opinion to Joe. Okay. Well, that's encouraging. I look forward to Joe's judgment on my judgment. All right, let's save the stream for this afternoon. Let's see. Download the link. Can the defense bring on psychologists or such during the hearing to say theft and murder is not likely? No. No, that's not really proper for a preliminary hearing like this. Not really.
Can defense bring in psychologist or such during this hearing to say theft to murder not likely? Or this all about prosecution?
Yeah. I think of all the law tubers, you're the one who knows the laws and the Constitution the most. Kurt, well, thank you, spiritual healer. I try very hard. I try very hard. To just be as fair as possible. And it makes me cranky when people accuse me of bias in particular, because I try so very, very hard. And, you know, I sometimes disagree with courts. I sometimes disagree with the Supreme Court. But I'd like to think it's because I've thought everything as well through as I can. And sometimes my judgment is just whatever it happens to be. Any witnesses for defense in prelim? I suppose it's theoretically possible, but I wouldn't expect it. We're just trying to make a threshold standard, right? We're not trying to like win or lose the case. We're trying to make a threshold. So is a defense witness in a prelim possible? Sure, but I wouldn't expect it, not in this context in particular. Peter's live. I can dump you over there. I'll dump you into Peter's stream. Please come back. I'll dump you into Peter's stream for this afternoon. Hold on. How do I do this? I have to find the right thing. I have to find the right place where it is. Hold on. All right. I'll dump you into Peter's stream. Everyone be nice over there. All right. I'll see you guys later. Love you guys lots. Please remember to come back. Talk to you guys later. Bye-bye.